Madam Clerk of Court, please call the cases before us.
Good afternoon, Your Honors. Scheduled for today's oral arguments are the consolidated petitions in GR number 274778, Aquilino Pimentel III et al., Petitioners, versus House of Representatives, represented by the Speaker, Ferdinand Martin Romualdez et al., Respondents. GR number 275405, Bayan Muna Chairperson Nery Colmenares et al., Petitioners, versus President Ferdinand Romualdez Marcos et al., Respondents. And GR number 276233, One Sambayan Coalition et al., Petitioners, versus the House of Representatives, represented by the Speaker, Ferdinand Martin Romualdez et al., Respondents.
Councils, please enter your appearances, starting with the petitioners, please.
Good afternoon, Your Honor. Respectfully appearing, Your Honor, as counsel for petitioner Pimentel et al., Paula May B. Tangking, Your Honor. Together with me, Your Honor, is Attorney Michael B. Ocampo.
Thank you. Your Honors, respectfully appearing for Bayan Muna, Petitioners Bayan Muna, and in GR number 275405, Your Honors, please, Nery Colmenares.
Good afternoon, Your Honors. Attorney Maria Kristina Yambot for Bayan Muna Petition, Your Honor.
Good afternoon, Your Honors. Attorney Catherine Jessica Distor Ginigundo, respectfully appearing for One Sambayan Coalition, members of UP Law Class 1975, and Father Flaviano Villanueva et al.
Good afternoon, Your Honors. Attorney Christopher Lau, respectfully appearing as counsel for Isang Bayan Coalition et al.
Good afternoon, Your Honors. Attorney Joseph Peter Calleja, respectfully appearing for Seniors Association, Inc., Kidney Foundation of the Philippines, and the San Beda Alabang Human Rights Group, Your Honor.
Good afternoon, Your Honor. Respectfully appearing for Petitioner Jose Sani Matula and the other trade union leaders as petitioners intervenors in the case of Pimentel, GR number 274778.
Good afternoon, Your Honors. I'm Solicitor General Menardo Guevara. The Office of the Solicitor General respectfully enters its appearance for respondents, House of Representatives, the Senate of the Philippines, the Executive Secretary, and the Secretary of Finance in GR numbers 274778, 275405, and 276233. The Office of the Solicitor General also represents President Ferdinand Marcos Jr. in GR number 275405. With me this afternoon, Your Honors, are Assistant Solicitor General Bernard Hernandez, Assistant Solicitor General George Ortha II, and Assistant Solicitor General Maria Victoria Sardillo. Other lawyers of the Office of the Solicitor General are in the gallery to provide assistance whenever necessary. Thank you, Your Honors.
Thank you. What about the Office of the Government Corporate Counsel for PhilHealth?
Good afternoon, Your Honors. Solomon M. Hermosura of the Office of the Government Corporate Counsel, appearing for Philippine Health Insurance Corporation, Your Honor. With me is Assistant Government Corporate Counsel, Melissa Montesilio Tacorda, and we have also other lawyers from the Office of the Government Corporate Counsel in the gallery who may provide us assistance. Thank you, Your Honors.
Thank you. May we know if the following are present as required during the preliminary conference as October 9, 2024. The Secretary of Finance, the Honorable Rod G. Recto. Thank you. The Honorable Teodoro H. Herbosa, Secretary of Health, Chairperson of PhilHealth Board of Directors. Thank you. Please be seated. PhilHealth President Emmanuel Ledesma Jr. Thank you. Members of the BOD PhilHealth, Secretary Bienvenido Lacuesma, Secretary Amina Pangadaman, Secretary Rex Lontiga Chalian. Thank you. The amicus are former Secretary of Finance Margarito Febes. Okay. Orbit Jose C. Solomon, Ziza Nadine M. Susara, Ms. Susani Africa, Ms. Beverly Lorenzi Ho. Thank you. As discussed during the preliminary conference in the advisory revised as of December 13, 2024, The party shall be heard in the following manner, with modification. A. The counsels for petitioners and petitioners in intervention shall be allotted a total of 30 minutes. Thereafter, the amicus curiae, in support of the petitioners, will speak. B. Counsels for respondents shall be allotted a total of 30 minutes. The Office of the Solicitor General representing the public respondent shall be given 20 of the 30 minutes allowed, and then 10 minutes for the Office of the Government Counsel representing PhilHealth. Thereafter, the counsels for responding, the amicus for the respondent shall also speak for 10 minutes each. The time allotted for counsels to argue shall be exclusive of the time of the interpellation of the members of the court. The interpellation will immediately follow after the parties shall be completed their respective presentations. The respective counsels of the parties or the party themselves or those required to be present during the oral arguments, including the amici curiae, may be called upon to respond to the interpellation of the members of the court. The members of the court may ask any question that they consider relevant to the resolution of the issue. The counsel for petitioners may now approach the podium for their presentation.
Chief Justice Alexander G. Mundo, Senior Associate Justice Marvic Mario Victor F. Leonen, Honorable Associate Justices of the Supreme Court, may it please the Court. As the final arbiter of all legal controversies, this Court is once again given the opportunity to uphold the rights of the citizens that the law and this very government has sought to protect. The case before your honors may be one of first impression, but it is all too familiar as it affects each and every Filipino. Today, I stand before you as a new mother. Having given birth via emergency cesarean section, I was fully aware of the potential cost, but I was nevertheless hopeful that as a consistent contributor for several years, PhilHealth would help defray some of our expenses. Regrettably, PhilHealth only shouldered less than 10% of our total expenses, constraining us to dip into our savings and settle the remaining amount. This may be my personal experience, but it rings true to all of us who may, at one point in their lives, avail of the healthcare services. The same can also be said about the petitioners in this case, who represent the spectrum of a typical Filipino family: senior citizens, breadwinners, single parents, retirees. Clearly, then, the case before this honorable court is more than just technical niceties and accounting procedures. Unlike what public respondent would like us to believe, data and statistics never lie. The purpose for which PhilHealth was created, to make essential goods, health, and other social services available to all the people at affordable cost, is far from fulfilled. In 2023, nearly 50% of Filipino families face significant financial barriers in seeking medical treatment. Despite the several mechanisms established to augment spending, these appear insufficient. According to the Philippine Statistics Authority, Filipinos are still constrained to make out-of-pocket payments accounting for 44%, almost half of the total current health expenditure in the country in 2023. These disheartening data presented appears to beg the question why funds as exorbitant as 89.9 billion even exist and remain unutilized. What legal or moral reason would exist to revert such amount back to the national treasury instead of using the same to resuscitate our already dilapidated healthcare system? It is these questions that petitioners urge this court to address today. Considering what is at stake, petitioners assail the constitutionality of the following government issuances for the protection of the PhilHealth funds, the Filipinos funds, to ensure that they are expended for the very purpose for which they were created. These issuances are Special Provisions Paragraph 1B, Chapter 43 of the Republic Act Number 11975 or the General Appropriations Act of 2024, allowing excess reserved funds of GOCCs such as PhilHealth to be returned to the National Treasury to fund unprogrammed appropriations, and Department of Finance Circular 003-2024, dated February 27, 2024, requiring the GOCCs to remit their fund balance to the Bureau of Treasury. In our proceedings today, the petitioners will convincingly establish that such issuances are constitutionally repugnant and should necessarily be struck down for the following reasons. First, the special provision in the GAA 2024 that directs GOCCs to transfer its reserve funds back to the National Treasury violates the prohibition in paragraph 5, section 25, article 6 of the 1987 Constitution, which prescribes the passage of any law authorizing any transfer of appropriations. Second, assuming arguendo that the president authorizes such transfer, the same remains unconstitutional. as the President himself cannot transfer special funds unless its purpose is abandoned or accomplished. Here, the petitioners maintain that the subject reserve funds are in the nature of special funds, having been collected for a specific purpose and can never be used for any other reason other than the health care of Filipino people. Thus, its transfer to the National Treasury to be utilized for a different purpose is prohibited. Third, the Universal Healthcare Act, which institutionalizes the National Health Insurance Program, expressly prohibits the transfer of such reserve funds back to the National Treasury, or government rather. Section 11 of the Act is unambiguous and deserve no other interpretation. No portion of the reserve fund or income thereof shall accrue to the general fund of the national government or to any of its agencies or instrumentalities, including government-owned or controlled corporations. Finally, DOF Circular Number 003-2024 constitutes a usurpation of the power of the President, as only the President is clothed with the authority to transfer public funds to augment any item in the General Appropriations Law for the respective office by savings in other items of an appropriation. After all is said and done, petitioners seek that this court rule as it has always done, not only with respect to the rule of law, but with compassion, that every Filipino would be entitled to the basic right to affordable health care. At the end of the day, may the words of WHO Acting Regional Director Dr. Zuzana Chakab be our reality. That no person should have to choose between whether to seek life-saving care or to feed their family. Thank you. Good afternoon again, Your Honors. Before delving into the merits of this case, petitioners will first establish that all the requisites to warrant this honorable court's power of judicial review under Article 8 of the 1987 Constitution have been complied with. First, there is an actual and justiciable controversy, which involves a conflict of concrete and definite legal rights and not one that is merely hypothetical or abstract. In determining whether an actual or justiciable controversy exists, the court in Universal Robina Corporation versus DTI clarified that actual facts resulting from the assailed law as applied may not be absolutely necessary in all cases. A clear and convincing showing of a contrariety of legal rights may suffice. Here, the requirement of contrariety of legal rights is clearly satisfied by the polarizing positions of the parties as to their interests and to their respective interpretations of certain constitutional provisions. On one hand, petitioners question the transfer of PhilHealth's reserve funds as it curtails the availability of cost-effective health services, thereby violating their constitutional right to health, while on the other, public respondents maintain that the challenge issuances must be upheld, having been done in accordance with law and the Constitution. Second, petitioners have the locus standi necessary to sustain the bringing and maintenance of this suit. As PhilHealth beneficiaries, it cannot be denied that petitioners have a personal and substantial interest, given that they stand to sustain or will sustain direct injury as a result of the enforcement of the assailed issuances. At any rate, the rule on locus standi is a procedural technicality that this court may choose to waive or relax in cases involving transcendental importance. Here, petitioners cry foul over the grave and imminent threat they face should such issuances be upheld, as it infringes on their right to health and consequently to a healthcare system that does not cause financial hardship, while prioritizing the needs of the population who cannot afford such services. Given that the outcome of this case involves public interest and has far-reaching implications for PhilHealth beneficiaries, it is apparent that the petitions involve matters of transcendental importance that warrant judicial resolution. Third, since the present constitutional challenge against the issuances was directly filed with this court, the requisite of judicial review of the earliest opportunity is complied with, as the issue of the constitutionality of the issuances were raised at the first instance. Fourth, the constitutionality of the assailed issuances is the very lis mota of this case. Verily, this case cannot be disposed on any other ground, as the determination of the constitutionality of the issuances would determine the validity of the transfer of the reserve funds to the National Treasury, which, according to the theory of the petitioners, violates the Constitution not only with regard to every citizen's right to health, but also on the provisions pertaining to appropriations and its transfer. In sum, The presence of all the elements for judicial review necessitates that this court exercises judicial power of review to its fullest extent. Therefore, resolution of these serious constitutional issues raised here today should not be delayed any longer. On a related manner, petitioners maintain that there was no violation of the principle of hierarchy of court in light of the clear judicial policy that a direct resort to this court is allowable in exceptional and compelling circumstances, such as cases of national interest and of serious implications, and those of transcendental importance and of first impression, as in this case. Also, there is no violation of the doctrine of exhaustion of administrative remedies, as the instant petition involves circumstances that demand urgency and that it raises purely legal questions regarding the patently illegal act of transferring PhilHealth's reserve funds to the National Treasury. And finally, the President committed grave abuse of discretion in certifying House Bill 8980 as urgent in the absence of any public calamity or emergency, as well as the dispensation of the requirement that printed copies of a bill subject to approval be distributed to the members in direct violation of Section 26, Paragraph 2, Article 6 of the 1987 Constitution. To close, given that all the procedural matters have properly been established, petitioners implore that this court would not shirk from its bounden duty to resolve the present constitutional challenge, as it guarantees that every person would have access to quality and affordable health care. The Filipino people deserve no less. Thank you.
Your Honors, please, for petitioner Bayan Muna. We have some slides, Your Honor, present to the court. May you request that the slides be presented. We were given the substantive issues: one, the validity of the presidential certification of urgency; two, whether the Congress can increase the budget as submitted by the President in the NEP; and three, whether the Bicameral Conference Committee or the BCC can increase the appropriation in the appropriations bill, and whether it can amend or insert new provisions not found originally in the general appropriations bill. Before I discuss the arguments, Your Honors, please, I'd just like to go over the timeline of the passage of House Bill 8980. On September 20, the President issued the Presidential Certification of Public Calamity or Emergency. On September 27, the House of Representatives approved on second and third reading HB 8980. On September 30, surprisingly, Congress goes on recess without transmitting HB 8980 to the Senate after its rushed approval on second and third reading. It was on October 4, Your Honors, please, that many realized the reason for the non-transmittal when the Philippine News Agency, a government news agency, publicly reported that Congress created a small committee to receive amendments to the proposed national budget already approved on third reading by the House of Representatives. Next slide, please. On the same report, the same government news agency quoted the House Appropriations Chairman public declaration of the chairman to quote, Your Honors, please, as authorized by the House and consistent with parliamentary precedent, the small committee has until October 10, 2023 to finish its task. Since the proposed amendments are of great interest to media and the Filipino people, we shall announce the changes at the proper time. On November 4, the House convened a special session and transmitted HB 8980 to the Senate. Apparently, the small committee failed to meet its deadlines of amending House Bill 8980, and it was only on November 4 that it was transmitted to the Senate. On November 28, the Senate approved on second and third reading HB 8980, and on November 29, both houses formed the Bicameral Conference Committee. On December 11, the BCC submitted its report to both houses of Congress recommending the approval of 8980. The Senate and the House simultaneously ratified the Bicameral Conference report, Your Honors, please. On December 16, the Congress again had its recess for the Christmas break. Next slide, please. The question I'd like to address in this point is whether Congress can increase the appropriations, including the UA submitted by the President under the NEP. Respondents claim that the UA is not part of the expenditure program in the BSF. Therefore, it is not the appropriation that cannot be increased as required by the Constitution. We disagree, Your Honors, please. The UA forms part of the appropriation submitted by the President and therefore cannot be increased. First, the UA is included in the NEP itself under the heading Proposed New Appropriations. It is also included in the BESF as part of the total new appropriations. The UA is even a part of the total new appropriations in the bicameral committee report itself. Your Honors, please. The UA, or the 731 billion UA by this time, is part of the 2024 GAA, also under total new appropriations. The UA is therefore part of the NEP, the BSF, and eventually part of the GAA. This was even subjected to a conditional veto by the President, Your Honors, please. If it is not part of the appropriation, the President has no reason to veto the unprogrammed funds of 2024. Because after all, why veto an item that is not really part of the appropriation? And the Constitution, Your Honors, please, says that the President may veto items or particular items of the appropriation bill. So we argue, Your Honors, please, that the UA, the unprogrammed funds, the unprogrammed appropriations are part of the NEP, the BSF, and the budget submitted by the President to Congress. The UA, next slide, please, in fact, is found at page 12 of the bicameral committee report. In that report, the lower part of the slide, Your Honor, the total new appropriations was 4.301 trillion. It already includes in the calculation the 281 billion of unprogrammed operations. Later, that report also says that the UA was increased by 449 billion. And the BICAM report later on calculated that the total new appropriation has increased to 4.7 trillion from 4.3 trillion. So we argue, Your Honors, please, that is part of the BSF, the NEP, the GAA. It's part of the President's budget submitted to Congress that cannot be increased. Next slide, please. Respondents also contend that it's not part of the appropriation because it's a mere standby fund. We argue, Your Honors, please, no, the UA is being spent every year in the entire budget season. In fact, 2019, 71 billion of UA was released. 2020, 192 billion was released as early as March of 2020. 2021, 222 billion released as early as February. In 2022, 183 billion was appropriated. We just don't understand why the total releases amounted to 209 billion. In 2023, 332 billion of UA funds were released by the government as early as January, when many of the program appropriations, Your Honors, please, are not even being funded. Inuna pa ang program fund kesa sa program appropriations. And of course, 2024, the subject of this petition, 438 billion has already been released as third quarter 2024, Your Honors. Next slide, please. So that is our argument that the UA is part of the appropriation that cannot be increased. Next. The next question, Your Honors, is the BCC increased the appropriation in the appropriation bill. Can the BCC do that? Respondents argue that congressional rules empower the bicameral committee to amend bills from the Congress, from the House of Representatives. We agree, Your Honors, that the rules of the House cited by the respondents indeed allow the BCC to amend the bills. But the amendment contemplated by the rules is on harmonizing disagreeing provisions of the bill. It is not contemplated that amendment covers new items which did not even pass second or third reading. So we argue, Your Honors, that basically this BCC power is beyond its authority under the Constitution, not just under the rules, Your Honors, please. First, the appropriation items and amount inserted by the BCC did not originate from the House in violation of Article 6, Section 24, which says that the appropriation bill shall exclusively originate from the House. It cannot originate from the BCC. It did not even go through second and third reading. It is as if the BCC said, well, you know, House, Senate, we know more than you. We can include here certain items you haven't thought about. In fact, the BCC is even telling the President as if that, look, Mr. President, there are 449 billion pesos worth of projects that you haven't even considered, Mr. President. We are the ones who do it. So it originated not from the House, but from the BCC, Your Honors, please. Secondly, the BCC is composed of senators also. In fact, in the 2024 budget, majority of the BCC were senators. And the senators cannot originate their own items of appropriation, Your Honors, please. So every time the BCC includes additional new items, partly the senators are part of that. And because this is ultra vires on the part of the senators of originating an appropriation item not included in the House of Representatives, it is ultra vires, Your Honors, please. Of course, the simultaneous BICAM appropriations are also a question for us because the Senate did not even approve, wait for the BCC report ratified by Congress. What did the Senate ratify? It was the BCC report, Your Honors, please. Did not come from Congress. The report came from the BCC. This violates the constitutional provision that it should originate. I will leave. I'm running out of time for this, Your Honors, for the presidential certification. But I just like to end and conclude. One, this is not merely about issues on a program fund. This is not merely an issue of budget deficits or public funds diverted to program appropriations that are nebulous, to say the least. This is actually also related to Article 2, Section 9, that the state shall promote a just and dynamic social order that will ensure the prosperity and independence of the nation and free the people from poverty through policies that provide adequate social services, promote full employment, a rising standard of living, and an improved quality of life for all. Thank you, Your Honors.
Your Honors, we also have a PowerPoint presentation. May we request that it be shown on the screen? The Honorable Chief Justice, the Honorable Senior Associate Justice, and the Justices of the Supreme Court. May it please the Court. Petitioners Pimentel et al. Submit that the Section 1D of the special provision of the unprogrammed appropriations in the 2024 General Appropriations Act is unconstitutional for being a rider in violation of Article 6, Section 25, Paragraph 2 of the Constitution. Next slide, please. This is the text that is being assailed, Your Honor. Next slide, please. In determining whether a provision in the General Appropriations Act is a rider or not, this court, the Honorable Court, has laid down the test of germaneness. To pass the test, a GAA provision must be particular, unambiguous, and appropriate. According to the court, a provision or clause is particular if it relates specifically to a distinct item of appropriation and does not refer generally to the entire appropriations bill or to some non-budgetary policy. It is unambiguous when its application or operation is apparent on the face of the appropriations bill and does not necessitate reference to external sources, other bills, other legislation. It is appropriate when the provision or clause and its subject matter does not necessarily have to be treated in a separate legislation. We argue that the assailed provision is not particular. It is actually a general policy on the financial management of GOCCs and proposes a new framework governing the transfer of monies from GOCCs to the national government, which before the assailed provision would have been governed by Republic Act number 7656 or the law on GOCC dividends. So this is an entirely new animal. It goes beyond setting qualifications, conditions, limitations, or restrictions on the unprogrammed appropriations. Contrary to what the respondents are saying, it does not only identify a funding source for the items in the UA. This is apparent from the plain reading of the special provision when it calls for the review, quote, review and reduction of GOCC's reserve funds to reasonable levels, taking into account the disbursement from prior years. Clearly, it creates a new policy framework. It is not appropriate because, as my colleague will argue later on fully, it amends the universal healthcare law and the syntax laws by diverting the funds that should be for universal healthcare, as clearly stated in this law, and using them for other purposes. To quote Gonzalez versus Macarig, while Special Provision 1D was artfully drafted to appear as if it's a condition or a source of fund, it is actually a general law measure more appropriate for substantive and therefore separate legislation. The assailed provision is likewise unambiguous to determine what is the fund balance. Can you go to the next slide, please? As shown by the DOF circular itself on how to compute the fund balance, you cannot just rely on the bill of our appropriations bill. You have to rely on the definition of the reserve fund under the UHC law. You have to look at the budget appropriations in previous years, among others. Therefore, we are not limited on the face of the appropriations bill and goes beyond that. And therefore, this provision fails the test of lack of ambiguity. Your Honors, the prohibition against rider is not a matter of procedural form. It goes to the foundational aspect of our democratic process, that is transparency in our legislative process, so that our legislators and citizens are fully informed of the subject matter of the legislation before Congress. The prohibition against riders becomes more important in the budget, a piece of legislation that is so voluminous, it's 3 volume this thick, and making it a very difficult Herculean task to monitor every. The evil sought to be prevented by our Constitution is exactly what occurred in this case, Your Honors. Weren't we all surprised that a seemingly innocuous provision on GOCCs, government-owned controlled corporations, turned out to have a serious adverse effects on the health of our people and our social health insurance system? This kind of dangerous repercussion, which the lack of transparency in riders can spring upon us, should be prevented. And we hope and we pray that the court will put a stop to it. Thank you very much.
We will also be using the same PowerPoint presentation, Your Honors. The Honorable Chief Justice, the Honorable Senior Associate Justice, and the Honorable Justice of the Supreme Court, may it please the Court. Your Honors, we argue that Special Provision 1D and DOF Circular 003-2024 must be declared as unconstitutional, as it impliedly amends Sections 10, 11, 37 of the Universal Healthcare Act, and the earmarking provisions of Republic Act 10351 as amended and Republic Act 11346, collectively known as the Syntax Laws. Provisions in an Appropriations Act cannot amend a substantive law, as this Honorable Court held in the cases of Philconsa versus Enriquez and Province of Batangas versus Romulo. Next slide. The question provision and DOF circular is inconsistent, incompatible, and irreconcilable with the Universal Healthcare Act and the Syntax Laws. UHC's objective is clear: to provide social health insurance and risk protection to all Filipinos. Social health insurance is a solidarity mechanism that requires the pooling of risk and resources. Financial pooling under the UHC requires solidarity. Those with the capacity to pay their own premiums, and those without the capacity to pay, the government pays for their premiums. The premiums of the indirect contributors are sourced from syntaxes, which are earmarked to be allotted to PhilHealth and used exclusively for universal health care. Next slide. There is therefore no distinction between the direct and indirect contributions, as they are considered one fund under the one fund policy of PhilHealth, which respondent PhilHealth admitted in their compliance dated November 7, 2024. PhilHealth likewise confirmed that their GA allocations are the premiums of indirect contributors sourced from syntaxes. Unfortunately, Congress has not only been appropriating less than what PhilHealth should be getting under the syntaxes, but it even took away the funds held in trust for its members, which should be used exclusively for their health needs. Social health insurance, Your Honors, also requires risk pooling, such that even if the benefits claimed Next slide, please. Even if the benefits claimed by indirect contributors exceeded the government subsidized premiums in almost all the years before 2021, the national government never once paid additional premiums or allocated additional subsidy, again because of the one fund policy. Thereafter, Section 11 is instructive. It requires the setting aside of 2 years of actuarially estimated projected expenditure as reserve funds. Then, any excess shall be used only for two things under Section 11. One, increase benefits and decrease the amount of members' contributions, and two, invest the same known as investment reserve funds. To ensure that this is met, Section 11 also unequivocally stated that no portion of the reserve fund or income thereof shall accrue to the general fund of the national government. Your Honors, taking away PhilHealth funds contradicts Section 11 of the Universal Healthcare Act and the concept of a social health insurance. In computing the alleged fund balance, DOF defied the clear language of the syntax laws, stating that these funds be used exclusively for universal healthcare. These funds were sourced from syntaxes and cannot be used for other purposes, irrespective of how noble the purpose is. Your Honors, Congress and DOF, as well as PhilHealth, breached the government's obligation mandated under Section 11 of the Universal Healthcare Act. The taking away of funds is a retrogressive measure, which is a violation of the constitutional right to health. The Universal Healthcare Act and the syntax laws are laws passed as a manifestation of the government's intent to protect and promote the right to health as a fundamental human right. Congress and the DOF violated this and infringed upon the social solidarity and social contract the government has with the Filipino people. A truly universal healthcare is one that provides financial protection, not one that takes it away. Our out-of-pocket spending, Your Honors, for health is one of the highest in ASEAN. Out of the overall health expenditure, social health insurance does not even account for the remainder as per the 2023 National Health Accounts. This explains the heavy financial burden of getting sick, which I am certain we all experience directly or indirectly. Your honors, let's not go far. The overwhelming number of patients in line at Philippine General Hospital's outpatient department at 4 o'clock in the morning speaks for the true state of health of our people. This and the numbers of PhilHealth's own financial statements. How can the government even claim there is excess funds? Your honors, by declaring Special Provision 1D and DOF Circular as unconstitutional, we will be able to stop Congress' abuse of its power of the purse and will uphold our constitutional right to health. Thank you.
Good afternoon, Your Honors. May it please the Court. Today, I am tasked to discuss the following. First, whether Special Provision 1D in the 2024 GAA is an invalid delegation of authority to transfer savings in violation of Section 25, Article 6 of the Constitution. And second, whether the DOF circular usurps the authority of the President to transfer appropriations to augment any item in the General Appropriations Law under the same provision. First argument. Special Provision number 1D under Chapter 43 of GAA 2024 is unconstitutional because there is no delegation of authority from the President to the Secretary of Finance to transfer appropriations in violation of the Constitution. The Constitution provides, no law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriations. Your Honors, the enumeration under the Constitution is exclusive. It does not authorize any government official to transfer appropriations. Moreover, the authority to augment any item in the General Appropriations must be given by law. Only the above-mentioned government officials, therefore, are authorized to transfer appropriations to augment any item in the General Appropriations for their respective offices from savings, if there are, in other items of their respective offices. The Finance Secretary is not among the enumerated officials that may authorize the transfer. The principle expressio unius, us exclusio alterius, is applicable in the case at bar. The express mention of one thing means the exclusion of others not expressly mentioned. PhilHealth funds that were transferred by the Secretary of Finance pursuant to the special provisions in paragraph 1D, chapter 43 of the GAA 2024 came from legislative appropriations under various laws. This is pursuant to section 29, paragraph 1, article 6 of the Constitution, that no money shall be paid out of the national treasury except in pursuance of an appropriation made by law. All these appropriations fall under the general prohibition in paragraph 5, section 25, article 6 of the Constitution, that no law shall be passed authorizing any transfer of appropriations. Thus, the said special provisions in the GAA 2024 violate the general prohibition in paragraph 5, section 25, article 6 of the Constitution. In the case of Malianas versus Comelec et al., this honorable court ruled that expressio unius est exclusio alterius proceeds from the premise that the legislature would not have made a specified enumeration in a statute had the intention been not to restrict its meaning and confine its terms to those expressly mentioned. Your Honors, even if authorized by the President, the transfer is still unconstitutional because the President himself cannot transfer a special fund raised for a specific purpose. PhilHealth funds are special funds that cannot be transferred unless their purpose is abandoned or accomplished. Second argument. The DOF circular usurps the authority of the President to transfer appropriations to augment any item in the General Appropriations Law under the Constitution. In the case of Blas Ople versus Ruben Torres et al., this honorable court ruled that as head of the executive department, the President is the chief executive. He represents the government as a whole and sees to it that all rules and laws are enforced by the officials and employees of his department. He has control over the executive department, bureaus, and offices. The Constitution is clear that it is the President who may, by authority of a law, transfer appropriations under Article 6, Section 25, Paragraph 5. Only the President may transfer public funds to augment any item in the General Appropriations Law for a respective office by savings in other items of an appropriation. The DOF Secretary, therefore, Your Honors, usurps executive power by transferring PhilHealth funds to the National Treasury, an act reserved by the Constitution only to the Chief Executive. Thank you very much. May it please the Court.
Honorable Chief Justice, Honorable Senior Associate Justice, Honorable Associate Justices of the Supreme Court, good afternoon. I'm going to discuss whether the directive to transfer 89.9 billion in PhilHealth funds violates Section 29.3, Article 6 of the Constitution. The answer is yes. Section 29.3, Article 6 of the Constitution reads, all money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. If the purpose for which a special fund was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. This must mean that the 89.9 billion PhilHealth funds are special funds, meaning raised by taxation. To be sure, we are only talking about this amount of 89.9 billion subject of the assailed directive and not the entirety of PhilHealth funds because, admittedly, PhilHealth funds are composed of funds from different sources, sin taxes being one of them. And yet, the government, through the Office of the Government Corporate Counsel, in the comment dated November 8, 2024, wishes to muddle the issue by saying that we are not talking about special funds because the funds are not entirely sourced from tax collections. The government adds that the funds include premium contributions from direct contributors. But has not the government, through its many surrogates, said that it is not touching these direct contributions? In fact, in the same comment, the government admits that these subject funds, which it refers to as fund balance, refer to the unexpended and unutilized premium subsidies for the fiscal years 21 to 23. According to the government, these subsidies have been released to PhilHealth as premium payments for indirect contributors and have become part of the National Health Insurance Fund. Now, where are these subsidies from? These are from revenues derived from same tax collections earmarked for health under RA 11346 and its IRR. Under RA 11346, out of the 50% of the total shares from both tobacco and sweetened beverages, 80% goes to PhilHealth for the implementation of the Universal Healthcare Act. For the fiscal years 21 to 23, the budget allocations for the premium of indirect contributors were under the GAA item called, quote, health insurance coverage under the sin tax law, unquote. And the amounts were 71.29 billion in 21, 79.93 billion in 22, and 79 billion in 23. The government next argues, even assuming the fund balance to be a special fund, its transfer is allowed if the purpose for which it was created has been fulfilled. The government reasons that upon the release of allocated funds to PhilHealth, they become part of the latter's accumulated revenues. The government's argument fails to impress. If the funds are meant for a specific health-related purpose, simply transferring them to general funds does not fulfill that purpose. The fact that these funds are still unexpended indicates that the purpose has not been complied with. Also, this reasoning contradicts the very foundation of how earmark funds should be treated. By this logic, there will be no distinction between special and general funds, effectively bypassing constitutional safeguards. As we stated in our petition, Your Honors, RA 11223 or the Universal Healthcare Act and its IRR outline a 10-year timeline for the full implementation of universal healthcare. Its IRR was signed in 2019 and is now entering its sixth year, yet it lags significantly behind its target. It is interesting that the government harps on the program reserve funds under Section 11 of the Universal Healthcare Act, when the same provision expressly states that no portion of the reserve fund or income shall accrue to the general fund of the national government. Also, PhilHealth's financial statement reveals that it does not have excess funds. May I direct the Honorable's attention to our PowerPoint? PhilHealth's 2024 first quarter financial statements show the members' equity as being negative 600 billion plus. This is signed by the highest officials of PhilHealth, an express admission by PhilHealth that its equity is negative by over 600 billion. Also, Table 58 of PhilHealth's 2023 notes to FS shows a mandatory 2-year reserve in the deficit. Given this, Your Honors, Secretary Recto's certification that PhilHealth has surplus funds is a grave abuse of discretion, showing evident bad faith. In sum, the institution of PhilHealth has not been abandoned, neither have its purposes been fulfilled. Thank you very much.
Good afternoon, Your Honors, Honorable Chief Justice, Senior Justice, and Associate Justices, Your Honors. I was assigned to argue that PhilHealth funds cannot be diverted from PhilHealth to the National Treasury. The transfer violates Section 11 of Republic Act 11223, and second, DOF Circular 003-2024 violates Section 70 of the General Appropriations Act of 2023. I know it's been a long day, and I promise not to bore your afternoon, with a monotonous legal discussion, but I must bring to your attention, Your Honor, something far more crucial than our afternoon coffee: the integrity of PhilHealth reserve funds and the healthcare security of millions of Filipinos. The law is clear, Your Honors. Section 11 of the Universal Healthcare Act states in no uncertain terms that no portion of PhilHealth reserve fund shall accrue to the general fund of the national government, not as laws change, not as emergency cash, and certainly not as an impromptu budget patch. Yet, the Department of Finance believes that the term "no" is just a polite suggestion. DOF Circular 003-2024 attempts to rewrite statutory law, violating not only the Universal Healthcare Act, but also the One Fund policy principle, and even worse, the constitutional prohibition on the transfer of appropriations. Article 6, Section 25, Paragraph 5 says, and I quote, "No law shall be passed authorizing the transfer of appropriations," unquote. And if that weren't enough, with all due respect, the DOF's so-called fund balance is built on a shaky arithmetic. Their numbers would have us believe that 78.8 billion for 2023 is just sitting there untouched. But let's do some simple subtraction. Of that amount, 28 billion hasn't even been released to PhilHealth by DBM. That means only 50 billion was actually given. And after covering expenses of 40.16 billion, what's left is nowhere near DOF's claimed excess. It's like being promised a full meal, receiving only half, and then being told to return leftovers you never even got. Just let's assume, just for fun, the DOF circular isn't, if it, the DF circular isn't unconstitutional, which it is, even then it still violates Section 70 of the General Appropriations Act of 2023. That provision is crystal clear. Appropriation for GOCC PhilHealth remain available until December 31, 2024, not whenever DOF decide it wants the money back. More importantly, transfer funds are not even considered disbursed until actually used for services rendered. And we all know that PhilHealth has been struggling with delays in hospital reimbursement. These funds should be paying for actual life-saving medical care, not taking the tour into the national treasury. Your Honors, to conclude, we affirm our prayers in our petition seeking to make the TRO permanent mandate, the return of 60 billion taken, and prevent the recurrence of the same unconstitutional act in the future. Thank you, Your Honors.
May we hear from the amicus curiae, Dr. Beverly Ho? Can we hear them?
Good afternoon, Your Honor. Universal healthcare simply means no Filipino will be impoverished due to healthcare spending. No Filipino will be denied appropriate healthcare because of their capacity to pay. No Filipino will die because they could not access healthcare providers on time. And no Filipino will need to beg for healthcare services. Service and cost coverage go hand in hand. But UHC also means healthcare workers are paid the right amount and in a timely manner. But the uncertainty in the healthcare system, particularly lack of predictable financing, holds us back from this dream of universal healthcare. For example, when health or benefit coverage is uncertain, the patients may be left to fend for themselves, depending on what disease they have. Also, when a payer or insurer's funding source is uncertain, for example, if annually decided or appropriated, it will likely err towards conservatism in expanding benefits. In the last 25 years worth of benefit expansion of PhilHealth, certainly much progress has been made with incremental piecemeal benefit expansion. Breadth of service coverage definitely is more, but outpatient service coverage, and in general, cost coverage for inpatient and outpatient services are still far from the dream as described in the law. For example, covered inpatient diseases are generally broad, but only 40% on average of total hospital bill is covered by PhilHealth. Of the 9,000 case rate packages of PhilHealth, only 17 of them, 17 disease conditions, have been upgraded to Z benefits, which are an elite form of benefits that actually are appropriately costed towards the entire clinical pathway from diagnosis to treatment. And you can say that these are the most generously covered. But for the rest of the case rates packages, you expect a lot of out of pocket payment from the patient. Another example, for the covered outpatient drugs of PhilHealth of 21 molecules, this only represents around 11% of the 189 drugs the DOH considered as critical and their primary care formulary. A stable source of financing is critical in reducing uncertainty of benefit expansion and timely payout to healthcare providers. Recognizing the fungibility of usual government funds, in particular line agency budgets in the Philippines, the health insurance fund model reliant on prepayments or premium payments that are ring-fenced solely for benefit payouts lends the required stability for benefit expansion. And in fact, you will see that because of massive increases in premium following the enactment of the UHC Act, there was indeed generous benefit expansion coverage starting 2023, 2024, and until now, early 2025. We know that the UHC Act was an enabling law for PhilHealth to shore up resources for aggressive benefit expansion. So for the first time in history, we actually have the necessarily legal and instruments and financial resources, not only to provide insurance coverage to every Filipino, but to expand benefits to a level necessary to finance and provide healthcare that Filipinos deserve. If we are to make this dream a reality, PhilHealth should maximize this cushion that's being provided to them to even rapidly increase their benefits. And more importantly, realizing this dream would require technical resources, whether it's retaining in-house talent or securing partnerships with academic and research institutions, similar to how health insurance bodies in other countries have done so. Just as we are determined to expand benefits, we know from experience that this cannot happen overnight without allocating resources and strengthening PhilHealth's ability to nurture technical experts and brain trusts within the sector to systematically enhance and regularly update the rates, instead of relying on development partners to fund piecemeal benefit expansion. We cannot keep outsourcing benefit expansion as has been done the last 25 years. Also, while checks and balances are necessary, audit bodies also need to update their auditing guidelines to constructively aid the full implementation of a mature payment system that will also allow PhilHealth the ability to pay providers in a way that's other countries have already successfully done so. The opportunity to have our healthcare system that Filipinos can be proud of is actually here. The opportunity is before our eyes, and we just need to make sure that the resources are actually translated to actual benefits that people can tangibly hold on to. Thank you.
May we call Mr. Sani Africa?
Good afternoon, Your Honors. I'm just hoping to give some raise some points to put the legal issues into context. We think the decision that the Supreme Court will make on the issues at hand will have significant social and economic implications. So I want to sort of put that into context. What are the implications, in particular, on the right to health of these kinds of cavalier decision making in the budget? But secondly, how this kind of approach to the budgeting actually does have implications. It compromises the budget's purpose of development and uplifting people's lives. It fuels deficits and debt because so much public funds goes to unproductive purposes motivated by narrow self-interest. And of course, it abuses processes and procedures for rational fiscal behavior, worsening, I think, a general problem of misprioritization and misallocation in the budget. In terms of the right to health, do want to highlight that first point, we do agree with the earlier points raised by the petitioners that the excess of PhilHealth reserve funds should be used to increase the program's benefits and to decrease the amount of member contributions. In that context, I think some contextual matters should be raised. Privatization of health in the last decades has actually made healthcare much more expensive. especially private healthcare, in the context that there are now more private hospital beds and private hospitals than public healthcare. So that is a big factor in increasing expense, therefore increasing the need for more financing from PhilHealth. Our submission also detailed the particular discrepancies in the mean cost of confinement and outpatient care, much more magnitudes of expenses in private hospitals, private institutions over public facilities. Second contextual point, we want to add the share of household spending going to health has actually been increasing, ironically, since the enactment of the NHIA decades ago. It was 2.2% of household spending in 1997, rising to as much as 3.7%, almost doubling by 2012 and 2015, and right now has settled at a high level of 3 to 3.3%. Also worth highlighting, this more expensive healthcare, this rising share of household spending going to health is in the context of clearly worsening poverty in the country. There are many sources, both from private survey outfits, but also even from a reasonable interpretation of government data. Poverty has been increasing, especially in the last 3 years. Household savings have been falling in the last 3 years. So in that context, any sort of diminution of PhilHealth benefits will affect the poor, low income, and even middle class households the worst. General point, of course, that reducing PhilHealth's finances makes it more difficult to meet already unmet targets. There's already talk about the very high out-of-pocket expenses, but again, to put that into context, the share of PhilHealth spending is actually down from its peak of 19.4% in 2015, down to its current rate of 10.2%. So again, instead of PhilHealth's share in expenses increasing, it has actually fallen, and just exactly at the time that budget cuts are being made. Second contextual point, PhilHealth contributions are actually greatly outpacing the claims being paid. If you look at PhilHealth claims, they were 129.6 billion in 2022, decreasing to 122.4 billion in 2023. If the effects of inflation are removed, the real value of claims paid in 2023 is actually worth even less than paid out in the 6 years before in 2017. So general point we want to stress, these underscore the need for PhilHealth to substantially increase benefits to relieve a greatly worsening health burden, especially in the poor and low-income majority. Last point on that, PhilHealth resources are being depleted not just by the 89.9 billion transfer, but also the allocation of just 61.5 billion, a reduced allocation in the 2024 GAA, which actually is the smallest in 6 years, and also on top of the 74.4 billion defunding in the 2025 GAA. Our second general cluster of comments are about the drastic budget cuts in PhilHealth, actually reflecting a larger problem of misprioritization of public expenditures. I want to highlight that health as a share of the budget has fallen from a peak of 6.9% in 2021 to 5.1%, for instance, in 2025. Similarly, social security, education, housing have also all fallen since over that period. On the other hand, if we take as a proxy for infrastructure spending, the budgets for power and energy, water resources, and roads and other transport, this has grown from 14.3% in 2020 to nearly 18% this year, including a large spike to 22% in 2023. Bottom line, infrastructure spending is over 3.5 times spending on health, and actually even larger than on education, which breaches arguably the constitutional provision that health and education should be given the highest share of the budget. Our bottom line, this pattern of deprioritization of social services, of which PhilHealth is just one example, shows that budget cuts are disproportionately borne by the poorest, most marginalized, and most vulnerable Filipinos, whose incomes are so low that they're the most dependent on publicly provided social services. We want to conclude with one last point. The additional budget items inserted by Congress, we support the notion that these are actually in breach of constitutional prohibitions. These additional budget items, one, results in great additional pressure for deficits, borrowing, and debt. As it is right now, any increase in the program appropriations, whether because fiscal space has been carved out or an outright increase, that actually is that corresponds to additional pressure on the budget. In 2024, that additional pressure was as much as 449.5 billion. But also, second point, apart from the definitely additional pressure, ipso facto, on deficits, borrowings, and debt, it does crowd out rational social spending, given the observed tendency to prioritize infrastructure and debt service over social services. Last point, we do want to support the view that the unprogrammed appropriations are part of the budget mentioned in the Constitution, whose appropriations Congress may not increase. The government's practice has for many years been to submit the BSF, NEP, and staffing summary and President's budget message as the budget before the opening of Congress. The purposes and items of the unprogrammed appropriations are also included in the GAA. The GA has had a section on unprogrammed funds since, as far as we can recall, at least 1989. Lastly, even if you look at the Administrative Code of 1987, it is very clear about the prohibition against increase of appropriations without any distinction on whether this is programmed or unprogrammed. So in conclusion, we are of the belief that the national government budget is a vital tool for development and in particular for upholding the economic, social, and cultural rights of Filipinos, especially those with the least capacity because of their poverty and vulnerability. Unfortunately, there's much reason to conclude the budget process is flawed and needs fixing. So much needs to be done to institutionalize a process for more human rights-based budgeting towards a budget that addresses the most urgent needs of the economy and the people. Thank you.
May we call Ms. Zara?
Honorable Chief Justice, Honorable Senior Associate Justice, and Honorable Justices of the Supreme Court, good afternoon. I wish to talk about these petitions in light of the public financial management context, and I also would like to argue that all of these things actually come after a pattern of surreptitiously funding pork barrel appropriations in the national budget. And the transfer of the 60 billion PhilHealth funds from the PhilHealth's reserve fund to the general fund is actually a consequence of these actions. Allow me to proceed. The national budget is the financial blueprint of development. In great detail, the annual budget document outlines the government's plan for the fiscal year and offers a glimpse of the country's fiscal and development trajectory in the short to medium term. The national budget is the clearest expression of any government socio-economic development agenda. The public budget is a product of choices and decisions made by different actors at multiple levels of government. The American political scientist James True identified two important levels of budget decision making. One, the subsystem level of technical personnel formulating the budget, and two, the macro political level of Congress and the presidency. In the same vein, another political scientist, Irene Rubin, argued that while most of the work involved in putting together a public budget is technical, it is intrinsically a result of political choices. Thus, the public budget is both a technical document and a political instrument. Rubin also pointed out that politics is present and exerts pressure in either of two possible modes: on the budget process itself and on the selection of policy tracks an administration wishes to pursue. The more forceful the actor, the greater potential for penetrating the system at multiple entry points across offices. Politics has a great deal of tendency to overpower technical and policy rigor in the public budget because those with the power to approve and implement the budget have inherent political considerations. As the petitions being considered show, the budget shows which policies survive the bureaucracy's technical rigor and whose political will triumphed behind closed doors. I wish to provide the relevant public financial management context on these petitions. I also wish to describe the new scheme of massively funding pork barrel, which involves the deliberate defunding of strategic development programs in the programmed appropriations and parking them instead in the unprogrammed appropriations. The freed up fiscal space is then allocated to legislators' pet projects. The new scheme of funding pork barrels circumvents the court's previous ruling in Bellica versus Executive Secretary in 2013, which declared as unconstitutional any form of post-enactment authority in the budget by legislators. The substantive issues in the said petitions are lamentable consequences of this new scheme. Article 7, Section 22 of the Philippine Constitution states, the President shall submit to Congress within 30 days from the opening of every regular session as the basis of the General Appropriations Bill, a budget of expenditures and sources of financing, including receipts from existing and proposed revenue measures. Book 6 of EO 292 or the Administrative Code provides the principles and procedures that govern the Philippine budget process. Apart from this, Book 6, Chapter 2, Section 4 of EO 292 also states that the budget shall be formulated as an instrument for the attainment of national development goals and as part of the planning, programming, budgeting continuum. Furthermore, the same provision mandates that budget priorities shall be those specified in the approved national plans, and as such, the budget must also be aligned with the Philippine Development Plan, the budget priorities of the presidential administration. About 6 to 8 months spent by the entire bureaucracy from the budget call until the budget or the national expenditure program is finalized and submitted to Congress. What types of appropriation are part of the national budget? The annual budget is composed of automatic appropriations and two new general appropriations. New general appropriations in the national expenditure program are broken down into programmed appropriations and unprogrammed appropriations. Unprogrammed appropriations is the part of the budget that does not have guaranteed sources of financing or cash cover. These are merely standby appropriations authorized by Congress. Originally, they can only be tapped when there are new or excess revenues or when there are additional foreign loans realized during budget execution. This is consistent with the constitutional provision on passing a supplemental appropriations. It should be noted that priority infrastructure and strategic socio-economic programs and projects are included as part of the budgets of various departments and agencies under the programmed appropriations of the National Expenditure Program. This is in order to ensure that they can be readily implemented during budget execution. There is no sense in putting priority infrastructure projects and development programs under the unprogrammed appropriations, which by nature are only standby appropriations. What is the new scheme for massively funding pork barrel? Congress deliberately defunded strategic infrastructure and development programs and projects and transferred them to the unprogrammed appropriations. This resulted in an excess of 450 billion in the unprogrammed appropriations of the 2024 General Appropriations Act. Historically, the level of unprogrammed appropriations in the enacted version of the budget do not deviate from its proposed level in the National Expenditure Program, except for fiscal years 2022, 2023, and 2024. The spikes in the level of unprogrammed appropriations were due to the deprioritization and transfer of various big-ticket foreign assisted infrastructure projects and other socio-economic development programs, which by the way are supported by other laws, from the programmed appropriations to the unprogrammed appropriations. In the 2024 General Appropriations Act, Congress fully or partially defunded multiple programs of various departments and agencies, such as the following: MRT Line 4 project, North-South Commuter Railway System, EDSA Greenway Project, the Pension and Gratuity Fund, the Revised AFP Modernization Fund, prior year's LGU shares, universal access to tertiary education, cold storage expansion, social pension for indigent senior citizens, etc., etc. From a proposed level of only 282 billion in the NEP, then programmed appropriations surged to 732 billion in the 2024 GAA. Congress then introduced the questionable Special Provision 1D, authorizing the fund balance of GOCCs as one of the sources of financing to provide cash cover for the now bloated and programmed appropriations. Congress also directed the DOF to issue guidelines for how Special Provision 1D will be implemented. Clearly, the specific sources of financing is not part of the original fiscal program reflected in the budget of expenditures and sources of financing submitted by the executive branch to Congress as mandated by the Constitution. While tapping GOCC funds instead of imposing new taxes or incurring higher debt may seem fiscally prudent, it should be emphasized that sound public financial management goes beyond effectively managing debt or revenues. A crucial aspect of fiscal prudence is the proper allocation of resources, and this must be evident in the budget. The budget should be driven by sound policies. Each and every line item should represent well-prepared plans that will deliver results. Congress severely distorted the budget by defunding strategic development programs and projects that were part of the original proposal in the program appropriations. What happened to the freed up fiscal space when the strategic and priority infrastructure projects were transferred to the unprogrammed appropriations? The 2024 GAA shows that an avalanche of funding went to departments where the hard and soft projects of legislators are traditionally lodged. These are the budgets of the DPWH, the DA, DSW, the DOH, and DOLE. The unprogrammed fund is no longer a list of general line items that could provide standby appropriations as it has always been used. It has morphed into a long list of line items that were eliminated by Congress in exchange for funding their pork barrel in the programmed appropriations. Congress has certainly found a way to circumvent the prohibition on post-enactment intervention, mangling the budget as it undergoes legislation. Worse, Congress authorized a questionable measure to finance the hundreds of billions worth of programs and projects that were defunded in favor of pork. The transfer of unutilized GOCC funds sets a dangerous precedent that will allow legislators to incessantly fund pork, all while justifying it as due to spending inefficiency of department, agencies, and GOCCs. But taking away unused funds is not the most effective solution to spending inefficiency. Institutional reform is. And institutional reform also costs money. There's currently no mechanism during budget legislation to safeguard the budget from these excesses. Furthermore, the absence of transparency in the bicameral conference committee meetings and the absence of any defined limits on the amount of pork barrel allocations make the budget ever more susceptible to abuse and misallocation. The funds of PhilHealth and other GOCCs were created under specific laws. In the case of PhilHealth, that is Section 8, Item C of the syntax law, which earmarks 80% of the remaining balance of the incremental revenues from excise taxes on alcohol and tobacco products. That particular provision, along with Section 11 of the Universal Healthcare Act, emphasizes no portion of the reserve fund or income shall accrue to the general fund of the national government or to any of its agencies or instrumentalities, including GOCCs. Special Provision 1B of the Unprogrammed Appropriations in the 2024 GAA violates both the earmarking provision of the syntax law under Section 8, Item C of RA 10351 and the prohibition to transfer any portion of the reserve fund of PhilHealth under Section 11 of the Universal Healthcare Act. Furthermore, the transfer of PhilHealth funds to the Treasury should be declared as unconstitutional because it also violates the constitutional provision on the transfer of appropriations. The 89.9 fund of PhilHealth identified by the DOF as its unutilized balance is an appropriation mandated by the syntax law, and it is included in the Annual General Appropriations Act as a subsidy to PhilHealth in compliance to both the syntax law and the appropriations provision of the Universal Healthcare Act. The only exception provided by the Constitution requires two things. One, the declaration of savings, and two, the augmentation of deficient items of appropriation. No declaration of savings was made when the 60 billion funds of PhilHealth was diverted to the Treasury. The funds were merely remitted to the Treasury in 3 tranches. And I'd like to emphasize as well that even if a declaration of savings was made, the funds of PhilHealth can never qualify as savings due to the prohibition explicitly stated under Section 11 of the Universal Healthcare Act. So in conclusion, the controversial transfer of PhilHealth funds to the Treasury operationalized through DOF Circular 003-2024 is a consequence of a larger and more serious problem. The new scheme of funding pork barrel despite the Supreme Court declaring PDAF as unconstitutional. Circumventing this earlier ruling, legislators have been deliberately defunding strategic development programs and projects in the programmed appropriations and transferring them to the unprogrammed appropriations, resulting in an excessive level of standby appropriations. This way of massively funding patronage-driven projects distorts the integrity of the budget and the budget process itself. My analysis of the 2022 to 2024 national budget reveals that pork barrel now constitutes nearly 20% of the total national budget. If left unchecked, politicians will continue to mangle the annual national budgets and divert any available funds of agencies or GOCCs deemed inefficient. The budget is the most potent tool for development. Without transparency and accountability on the part of Congress and the executive branch, how can taxpayers' money work for taxpayers? Thank you.
Thank you. The court calls for a 5-minute break.
cannot be sued during his tenure. In GR number 275405, this court has categorical procedural matter. Everyone else listening in. I would like to begin on a procedural matter. I would like to respectfully ask the Honorable Court to drop President Ferdinand Marcos Jr. as party respondent in GR number 275405. This court has categorically ruled in Colmenares versus Duterte, citing Nepomuceno versus Duterte, that the President of the Republic cannot be sued during his tenure. His immunity applies regardless of the nature of the suit against him. I find no reason for the court to depart from this well-settled doctrine. To continue, Your Honors, the political branches of our government have been unjustly vilified on account of the fund balance transfer from the Philippine Health Insurance Corporation to the Bureau of Treasury. Insidious motives have been imputed upon respondents. They have even been accused of technical malversation, even plunder. I am therefore glad that today I am given the opportunity to provide the proper context for the actions of, and in the process vindicate, the executive and legislative branches of government. I assure the Honorable Court and the people that, contrary to what has been portrayed by some critics, there was no dark or sinister plan behind the transfer of the 16 billion peso fund balance from PhilHealth to the Treasury. Rather, I will emphasize that said transfer was a temporary measure to address, within legal bounds, of course, concerns on fund availability for important government programs and projects. Under our system of government, such concerns fall exclusively within the mandate shared by the executive and the legislative departments. As this Honorable Court declared in the case of Sihuko Jr. versus Abaya, quote, the executive branch determines the government budgetary priorities and activities in line with available revenues and borrowing limits. The Congress, in turn, deliberates and acts on the budget proposals of the President. Once the Congress approves the national budget and legislates the General Appropriations Act, the Executive Department exercises all roles and prerogatives in the implementation and enforcement thereof, unless otherwise provided by the Constitution, unquote. Amidst this interplay of powers, the Department of Finance takes on the primary responsibility to manage in a sound and efficient manner the financial resources of the government, its subdivisions, agencies, and instrumentalities. In a sense, the DOF acts as custodian and manages all financial resources of the national government. As the government steward of sound fiscal policy, the DOF formulates revenue policies to fund critical government programs that promote welfare among our people and accelerate economic growth and stability. Consequently, the DOF must generate and manage financial resources to help attain the government's development objectives. Primordial among these objectives is the provision of basic public services in the fields of health, education, and infrastructure, among others. As luck would have it, however, the money needed to provide these essential services does not come easy in our side of the world. But as they say, scarcity breeds creativity. And oftentimes, creative and innovative solutions are born out of something as common as common sense. The honors, the Congress's inclusion of Special Provision Number 1B in the General Appropriations Act of 2024 and the DOF's issuance of Circular Number 003-2024 are the government's common sense approach, again within legal bounds, to temporarily eke out the cash needed for the national government's numerous priority programs. Under Special Provision Number 1D, the unprogrammed appropriations shall be sourced from any remainder resulting from the review and reduction of the GOCC's reserve funds to reasonable levels, taking into account the disbursements from prior years. Here, you can see that the Congress, in the exercise of its sound judgment, considering the exigencies of the times, found it necessary to, number one, direct GOCCs to review and reduce their reserve funds to reasonable levels on the basis of their previous annual disbursements. And number two, once the new level of reserve funds has been determined, to utilize the remainder for the financing of the unprogrammed appropriations. This remainder is the pool from which the so-called fund balance would be computed. Pursuant to this congressional directive, the DOF issued its assailed Circular Number 003-2024 to lay down the necessary guidelines to implement Special Provision Number 1D. The DOF defined fund balance as the unrestricted funds of the GOCCs in the form of cash, investment in securities, and government subsidy, among others. In the case of PhilHealth, the fund balance was computed by adding the total amount of government subsidies for indirect contributors, such as senior citizens, indigent persons, persons with disabilities, for the years 2021 to 2023, and subtracting the total amount of benefit claims of indirect contributors during the same 3-year period. During this 3-year period, the total government subsidies to PhilHealth amounted to 239.11 billion pesos, while the total benefit claims of indirect contributors amounted to 149.23 billion pesos only. In particular, the government subsidies exceeded the total benefit claims of indirect contributors by 27.12 billion pesos in 2021, by 23.97 billion pesos in 2022, and by 38.79 billion pesos in 2023, for a total of 89.9 billion pesos. PhilHealth's fund balance of 89.9 billion pesos was thus an accumulation of 3 years' worth of government subsidies which had remained unexpended or unutilized as of the end of 2023. What then should we do with this unutilized surplus? The 5.7 trillion budget for 2024 could only fund the programmed appropriations for specific priority projects that were intended to foster economic and social transformation and mitigate the effects of inflation on basic commodities, as well as to advance the government's 8-point socioeconomic agenda. In the 2024 GAA, however, other important programs, from government infrastructures to health-related and other social programs, were identified but would have to stand by until new or additional financial resources became available. These were the unprogrammed appropriations. It might have been less complicated if the national government simply borrowed money. But then we must consider that as of the end of February 2024, the national government debt was already recorded at 15.8 trillion pesos. Based on a population of 114 million in 2025, every Filipino, young and old, rich and poor, able and disabled, is indebted in the amount of 139,000 pesos each. This is rather heavy. It is in this cash-starved context that the Congress trained its sight on money that was there but was not being productively utilized. Respondent Congress, in its wisdom, identified the fund balance of government corporations as a source of additional funds to finance the unprogrammed appropriations. Respondent DOF, in issuing circular number 003-2024, merely implemented the congressional directive. More importantly, the DOF issued circular number 003-2024 in fulfillment of its mandate to generate and manage the financial resources of the government judiciously and in a manner supportive of development objectives. This is the legislative wisdom behind Special Provision number 1B, as implemented by DOF Circular number 003-2024. It was the executive and legislative department's way of creating and implementing a fiscal policy to boost economic growth without bloating the government's indebtedness or burdening the people with new tax measures. It is a common sense approach that does not violate any law, much less the Constitution, in any way. Given the foregoing, it is our submission that, number one, at the time the petitions were filed, and even so now, the requisites for the Honorable Court's exercise of the power of judicial review were not satisfied. Number two, Special Provision number 1D in the 2024 GAA, which authorized the use of government corporations' fund balances to finance the identified purposes in the unprogrammed appropriations, is a valid enactment for the following reasons. Letter A, respondents did not violate Section 25(1) of Article 6 of the Constitution, which prohibits the Congress from increasing the appropriations recommended by the President for the operation of the government as specified in the budget. Letter B, being germane to the purposes of the 2024 GAA, the subject special provision is not a rider. Letter C, neither does it violate Section 25(5), Article 6 of the Constitution, for the simple reason that it does not involve savings as presently defined, nor is it an illegal transfer of appropriations. Letter D, it does not contravene Section 29(3) of Article 6 of the Constitution, considering that the amounts collected from sin taxes are not hard earmarks, resulting in the creation of a special fund in the manner, for example, that coconut levies constitute a special trust fund. Letter E, the bicameral conference committee acted within the bounds of its authority. We further submit that DOF Circular number 003-2024 is valid for the following reasons. Letter A, the DOF was specifically authorized by law to provide the guidelines to implement Special Provision number 1D. Letter B, no part of the corpus of PhilHealth's reserve fund, after having been reviewed and reduced to a reasonable level, reverted to the National Treasury. Letter C, only PhilHealth's excess fund, amounting to 60 billion pesos, was remitted to the Treasury and in the process contributed to the implementation of health-related programs amounting to about 46 billion pesos under the unprogrammed appropriations. Letter D, the Secretary of Finance did not usurp the President's authority to transfer appropriations to augment any item for the simple reason that, as earlier explained, the process did not involve savings as presently defined under the GAA. Your Honors, I'll be ready to expand on any or all of this during the interpellation. Indeed, our government will not be acting with common sense if it shelves other much needed projects because one pocket is short on funds, while knowing fully that there is abundance in the other. Using the petitioner's own words, there can be no greater act of negative social justice and disservice to Filipinos if that were to be the case. Mr. Chief Justice, honorable members of this court, thank you for your time and attention. I will now turn over the floor to Attorney Solomon Hermosura, Government Corporate Counsel, who will discuss the core issue of right to health.
May, may it please the Honorable Chief Justice, the Honorable Senior Associate Justice, and the Honorable Associate Justices of the Supreme Court. With the permission of the Honorable Court, on behalf of Respondent PhilHealth, I will now proceed to establish the following 3 points. 1. PhilHealth's remittance of its fund balance to the National Treasury in compliance with DOF Circular 003-2024 is lawful. It is lawful because contrary to the claims of petitioners, the fund balance is not part of PhilHealth's reserve fund. And the funds of PhilHealth, including that part sourced from sin taxes, are not a special fund under the Constitution. 2. PhilHealth's compliance with the DOF circular does not impair the constitutional right to health. Despite its remittance of 60 billion to the Treasury last year, PhilHealth's operating budget for 2025 increased to 284 billion, higher than the 2024 budget by 25 billion. The operating budget of PhilHealth has increased by 58% during this administration, from the 2022 budget of 166.5 billion pesos. While advancing universal health care, PhilHealth observes fiscal accountability and good governance, an essential prerequisite for our national development. 3. These cases should not have reached this honorable court. They should be dismissed because petitioners who are suing as PhilHealth members made no attempt to exhaust administrative remedies before resorting to this honorable court. Petitioners ignored the PhilHealth's board quasi-judicial powers under the National Health Insurance Act to hear and resolve grievances from members, including complaints against alleged act, to quote from the act or neglect that tends to undermine or defeat the purposes of this act. Allow me, please, Your Honors, to elaborate further on these 3 points. PhilHealth's transfer of its fund balance to the Treasury is lawful because the fund balance is not part of the reserve fund, and PhilHealth's funds, and to repeat, including that part from sin taxes, are not a special fund under our Constitution. Both under the National Health Insurance Act and the Universal Health Care Act, the reserve fund is, and to quote from the two laws, that portion of PhilHealth's accumulated revenues not needed to meet the cost of the current year's expenditures that PhilHealth set aside as the reserve fund. So the reserve fund is merely a portion of accumulated revenues, not the whole of the PhilHealth funds. As of December 31, 2023, PhilHealth has a reserve fund of 280.60 billion pesos and a fund balance which is separate from the reserve fund of 183.70 billion pesos. Not being part of the reserve fund, PhilHealth's fund balance is not subject to Section 11 of the Universal Health Care Act, which directs that no portion of the reserve fund or income thereof shall accrue to the national government. PhilHealth's funds also do not constitute a special fund, which under our Constitution consists of, to quote, money collected on any tax levied for a special purpose. This honorable court has given us an example of such a special fund, the Coconut Investment Fund, also referred to as the Coco Levy Fund. The fund consisted of money which, pursuant to the Coconut Investment Act, was, to quote from the Act, levied on the coconut farmer to constitute a special fund which shall be used exclusively to pay the subscription by the Philippine government to the capital stock of the Coconut Investment Company. The Universal Health Care Act and the sin tax law do not levy any tax on any particular sector, do not levy a tax for a special purpose, and do not provide the levy of any money to constitute a special fund. They also do not amend the National Health Insurance Act, which provides that, and I quote, all funds under the management and control of the corporation, meaning PhilHealth, shall be subject to all rules and regulations applicable to public funds. Let me also add that the appropriations for PhilHealth for the subsidies of its indirect contributors are constituted as premium payments. That's the language of the law. To PhilHealth pursuant to the National Health Insurance Act. Thus, when they are released to PhilHealth, the appropriations are paid out for the purpose for which they are allocated under the Universal Healthcare Act and the sin tax law. Accordingly, Your Honors, the allegations of technical malversation are too unkind at the very least. PhilHealth should be encouraged, not threatened with criminal liabilities for submitting to DOF's policies for sound fiscal management and good governance. Let me now proceed to my second point, Your Honors. PhilHealth's compliance with the DOF circular does not impair the constitutional right to health. As I mentioned earlier, despite the remittance of 60 billion pesos of its fund balance to the Treasury last year, PhilHealth increased its operating budget for this year to 284 billion pesos, higher than last year's budget by 25 billion pesos. PhilHealth's board and management are doubling their efforts to advance universal health coverage. In 2024, PhilHealth increased the all-case rates package by at least 95%. PhilHealth also approved and implemented massive enhancements in outpatient packages for chronic conditions to offer greater coverage for critical and life-saving treatments. If so required by this Honorable Court, PhilHealth can submit in writing more information on its plans and programs to accelerate the realization of universal health care. In its Section 2 on Declaration of Principles and Policies, the Universal Healthcare Act prescribes the adoption of a comprehensive approach, model, or framework as the first step for our country to realize universal healthcare. Funding comes after the development and adoption of programs. Thus, we submit that there is no violation of the people's constitutional right to health when PhilHealth adheres to fiscal responsibility and submits to the authority of the President and the Secretary of Finance to respond to the imperatives of the national interest while carrying its mandate to advance health care. Now to our third and last point, Your Honors, is that these cases should be dismissed for petitioners' total disregard of the PhilHealth Board's quasi-judicial powers to hear and resolve grievances from members, including complaints against alleged act or neglect that tends to undermine or defeat the purposes of the National Health Insurance Act. One guiding principle for our National Health Insurance Program is social solidarity, which the National Health Insurance Act also refers to as community spirit. Thus, the program, to quote from the Act, shall serve as the means for the healthy to pay for the care of the sick, and for those who can afford medical care to subsidize those who cannot. Consistent with the community spirit, Section 39 of the Act establishes a grievance system wherein members who believe they have been agreed by any decision of PhilHealth may seek redress. The Act grants the PhilHealth Board of Directors quasi-judicial powers to resolve those grievances. One such grievance is the complaint of petitioners that PhilHealth remittance of its fund balance to the Treasury favors subsidized members at the expense of paying members. We plead for this Honorable Court to enforce compliance with the grievance system under the National Health Insurance Act. That will enhance, Your Honors, engagement among the PhilHealth stakeholders and promote social solidarity or community spirit. And the National Health Insurance Program as the means for the healthy to help pay for the care of the sick and for those who can afford medical care to subsidize those who cannot. As a final note, Your Honors, may I state that PhilHealth joins the other respondents represented by the Office of the Solicitor General in all their arguments for the dismissal of all the petitioners. Thank you, Your Honors.
May we call Mr. Corbin Soda for his presentation?
Good afternoon, Your Honors. Let me try to focus on summarizing to 4 points the arguments that I've sort of laid out in the brief that I sent earlier. Let me also point out that I'm going to be speaking to all of you as an economist, and I'm going to focus on the relationship between budget and finance and incentives and performance. The emphasis is that the way you deliver and provide financing not only allows you to perform your duties, but also affects how you do that, the kind of efforts that you put in. So the first question that I would all of us like to sort of look at is why has this unused fund persisted for the longest term? The materials that have been circulated and has been going on looks at 2018, 19, 20, but colleagues of ours at the UP have been monitoring healthcare financing since the enactment of the 1995 PhilHealth law. And we point out, and it's detailed in the brief, that only perhaps in a 4 or 5 year period did you see contributions equal to that of payments. The rest of the 30 years that we've looked at, contributions are way much higher than what it was relative to benefit spending. So PhilHealth was receiving more than what it could actually spend in terms of. These unused funds persist over a long period of time for 4 sets of reasons. One, and this was raised by us maybe in 1993 when then Secretary of Health and Senator Flavier asked, and under the auspices of Senator Webb and Senator Angara, first discussed the PhilHealth law. I was one of those who raised red flags against the enactment of the PhilHealth law in 1995 for a number of reasons. One, there was no clear identified funding. Maybe now we do have funding for it. Second, the administrative infrastructure was not there. What did I mean? Why were we worried about administrative infrastructure? The business of providing insurance is relatively complex, unlike pensions and death. Here, the events are very complex and varies widely throughout the population, young and old, whether you're in the Visayas or Mindanao, the risks and the utilization patterns are going to be different. And you need a solid base in terms of administrative information system, or in short, your actuarial technical base, to actually determine the best way of using available funds. Absent that, then we will deal with sort of across the board benefits that are targeted at this notion of the average Filipino family. The second set of weaknesses that we've observed over the years is that operating budgets have not been linked in very specific ways to performance, to benefit delivery in particular. And I mentioned this period of 2012, 15, maybe up to 2017, when benefit spending closed the gap in terms of the contributions that PhilHealth received. And what was happening then was that the DBM and Congress and the Department of Health had very concrete performance delivery measures that were used to trigger fund releases. And that was the mechanism then was that the DOH transfers from DBM to the DOH would be on the basis of reported accomplishments of those performance triggers. And even Congress had those performance indicators specified in special provisions. I don't think that sort of mechanism is in place. And I, as an economist, would argue that that's one reason why the benefit spending and the premiums or the revenues that PhilHealth receives have diverged again. The third set of reasons, and I'm beginning to sort of move from very immediate proximate reasons like the administrative information system to more structural. The third one, which is more structural, is that supply of the ability of medical providers to provide for mandated or covered PhilHealth benefits vary widely across the country. And yet, every Filipino, wherever he is or she is, is given that same subsidy. So what use would that subsidy for cancer treatment or for this particular service for a Filipino, let's say in Samar or in BARMM? In other words, what can your vouchers do? What can financing power do when there is nothing, no services available that you can use? What happens is that unused funds are generated because you are giving cash and subsidies and vouchers to everybody, but everybody does not have the same opportunity for using. So naturally, what's going to happen is that there will be excess money, which for me explains the long-term persistence of such funds. Finally, the fourth set, which is related to the third one about supply, is our public healthcare delivery system is actually managed by cities, provinces, and municipalities, whose management changes every 3 years, who are independent by law and by their mandates. It's very hard to coordinate. So when you deliver new packages, PhilHealth gets more money from a new tax. You want to provide for, according to the law, primary care, according to UHC. Okay, who are the main existing providers for UHC? These are the independent localities managed by mayors and so on and so forth, which has been fragmented for the longest term. You would notice that in the law, you would have these elaborate mechanisms introduced called special health funds, supplier provider networks. These are attempts to sort of put together a fragmented system, the success of which we still have to see. The third, now, what I'm saying is that these excess funds will persist for reasons that are different. And the second point that I'm going to make is that whether the excess funds are transferred or retained will send a signal that's incentive performance for PhilHealth. In other words, if excess funds obviously represent not the power to purchase more, but it also represents, from a person like an economist who just looks at things in a very dismal way, it also represents missed opportunity to pay for services. That there is money on the table means benefits have not been provided. That's equally deplorable than this whole idea of removing money away from health. The incentives that are important for us to look at is that, one, as we mentioned, budgets need to be linked to very well-defined, measurable by Congress as oversight and even by courts, linked to performance. And this has to be key performance indicators need to be attached to individual members, not the average Filipino or not indigents, not paying workers, but to individual members. In other words, we should be able to compute how much the contribution has been for each individual member and how much benefit it has already been used and how that varies across the country and how that variation needs to be sort of equalized. In short, when I was reading the documents that was sent to me by the Honorable Court, the quote that came to mind from an economist perspective is that we always talk about, well, you use it or you lose it. That's the spirit of the kind of signal that needs to be sent. In other words, if the court decides that the money remains, it has to be made conditional on certain reforms. Otherwise, that money will still keep on becoming unused. If it has to be transferred, it has to be transferred given conditions for reform. Lastly, as I'm already talking about my third point, which is, well, the court is in a position to actually trigger reforms. That this case has been presented here and being argued, this is an opportunity to trigger reforms within PhilHealth. Whatever your decision, reforms have been triggered. I have been personally, and my colleagues have been involved in sort of trying to put together an agenda or list of things that need to be changed. For this afternoon's purposes, and which I detail in my brief, let me just talk about three nudges, little things that we can push and change that might matter and help avoid this kind of discussion again. One is very simple. Let PhilHealth invest in a truly competent, technically equipped actuarial department. These are the baseline sort of scientific backbone that you would need for us to determine what is the best use for this money, what is the premiums that we need to collect and ask from JAA, etc., etc. That needs to be strengthened and kept at a high level of competence. The second one is that the PhilHealth's corporate budget should be clearly linked to benefit delivery at subpopulation groups, if not at individual levels. In other words, some years ago, Secretary Romualdez and I would sort of sit down one afternoon and we'd say, ideally, everybody should receive the same kind of pamphlet that health insurance companies would send to us, describing the benefits and tailoring it to you at the individual level. That's the kind of relationship of benefit delivery sort of attention that Filipinos sort of deserve. The third one, lastly, is that what might be the best use of whatever funds are available? One way is to begin to address our supply disparity by actually using a term which I would define in my brief called global budgets and target it for providers in remote areas who need assistance in upscaling their capacities. That is one way of using money. In the end, as an economist, just to close, public funds are very scarce and it costs a lot of money to tax people, and it has welfare effects. And so it has to be handled preciously. And so for me, the presence of excess funds and how it needs to be resolved, whether it should be transferred or kept, is a signal that is related to PhilHealth performance. Thank you very much and good afternoon.
May we call Secretary Teves to the rostrum? Thank you.
Honorable Chief Justice, Senior Associate Justice, Associate Justice, good afternoon. The national budget is the most critical piece of legislation that Congress passes every year. It is the primary tool of the government to put its plans and policies into action. This includes access to affordable and high-quality healthcare services for Filipinos regardless of financial status. To operationalize the national budget, it must be supported by revenues which can either be tax or non-tax. Tax collections include taxes on net income and profit, for example, personal and corporate taxes. Tax on domestic goods and services, such as value-added tax. And tax on international trade, for example, import tariffs. Meanwhile, non-tax collections would include the fees and charges, dividends from government-owned and controlled corporations, and select sale of government assets and privatization of government-owned and controlled corporations. If revenues are not enough, the remaining balance of the expenditures will be sourced through domestic or foreign borrowings. The responsibility of generating these revenues is vested on the Department of Finance and its attached agencies. The difference between the expenditures and revenues is the deficit. Prudent fiscal management means ensuring the deficit levels are sustainable for continued confidence in the country's future economic performance. The fiscal situation of the Philippines. The COVID-19 pandemic response of the government drastically changed the fiscal trajectory of the country by substantially increasing both the deficit and debt levels in absolute and relative terms. The government needed to spend more to distribute financial assistance to affected families and businesses, provide incentives to healthcare workers, and purchase vaccines. Meanwhile, revenues declined sharply due to the lockdowns that forced businesses to halt operations. As a result, our debt to GDP ratio ballooned from 39.6% in 2019 to 54.6% in 2020, while our deficit to GDP ratio widened from 3.4% to 7.6% during the same period. The government's fiscal position is still recovering from the impact of the COVID-19 pandemic. In 2014, the debt to GDP ratio, in 2024, the debt to GDP ratio expected to be 60.6% with a deficit to GDP ratio of 5.7%. Converted to actual figures, the 5.7% deficit to GDP ratio is equivalent to a total fiscal requirements of 5.9 trillion pesos, with 4.4 trillion raised from revenues and the remaining balance of 1.5 trillion representing the deficit that has to be funded from borrowings. The government has also released a medium-term fiscal framework which outlines the fiscal targets until 2028. By 2028, the debt to GDP ratio is expected to go down to 56.3% and the deficit to GDP ratio to 3.7%. This is the context upon which our economic managers are operating. The existence of unprogrammed appropriations. The items outlined in the national budget can be classified into two, program and unprogrammed. Items listed in the program appropriations have definite sources of funding, as indicated in the budget of expenditures and sources of financing, or the BESF. Conversely, unprogrammed appropriations, or UAs, do not have definite funding sources, except for foreign assisted projects, which can be funded through approved foreign loans. All other UAs are on standby and are funded only when one of the following usual conditions is met. One, the national government collects excess revenue from non-tax sources against targets. And two, revenues from new taxes or sale of select government assets and proceeds from the privatizations of GOCCs previously not included in the original target. A reasonable amount of UAs is necessary to cover expenses arising from unforeseen events, since the national government budget is prepared 1 year ahead of time. The existence of the UAs allows for these programs and projects to be potentially funded in the future, rather than be removed from the General Appropriations Act outright, thereby giving the NG sufficient fiscal flexibility. Under the 2024 GAA, Congress authorized the Finance Secretary to collect unused idle funds of GOCCs to fund UAs, maximizing the use of idle public funds. Utilizing idle public resources towards productive programs is a prudent fiscal strategy. Previous administrations have authorized the transfer of idle resources to support the country's fiscal needs. During the Ramos administration, all government offices and agencies were required to immediately transfer all funds deposited with banks to the Bureau of Treasury, and this was indicated in Executive Order number 338, 1996. During the Arroyo administration, the permanent committee composed of secretaries of finance and budget and the chairperson of the Commission on Audit was tasked to review the existing cash balances of government agencies, as well as the necessity of existing trust and special funds maintained by these agencies. Again, Executive Order 431. During the Duterte administration, the Bayanihan 1 and 2 laws contain provisions to reallocate the idle resources to fund the COVID-19 emergency response of the government. Returning the 89.9 billion idle funds of PhilHealth will not hamper its ability to provide services to all its members, including indigents and senior citizens. PhilHealth remains in a strong financial position, even with a return of 89.9 billion fund balance. It has sufficient resources not only to continue covering the benefits of all its members, including indigent population, but also introduce better packages. As of quarter 3, 2024, PhilHealth has 682.2 billion pesos in assets, 81% or 510 billion of which are liquid. PhilHealth's liquid assets are sufficient to settle existing and current and non-current liabilities amounting to 182 billion. Lastly, PhilHealth has 424.7 billion in combined surplus and reserve funds. The national government at this stage, Your Honor, is in a better position to spend the 89.9 billion productively for government projects and programs. For example, this can be used to build more health facilities, such as barangay health stations and hospitals, as well as purchase medical equipment such as X-rays and CT scan machines. The 89.9 billion can also be used to fund education, nutrition, and growth-enhancing infrastructure programs and projects to address the social determinants of health, or SDH. The SDH are non-medical factors that influence health outcomes. National government agencies, Your Honor, operate with the understanding that they have to use their budget. Consistent with that understanding, the national government can restore or even increase the subsidies for PhilHealth in the future, provided it can demonstrate improved capacity to implement more generous benefit packages for its members, including indigents and citizens. Thank you very much, Mr. Chairman.
Thank you. Justice Ami Javier will proceed with her interpellation.
Thank you, Chief Justice. May I call on the Government Corporate Council to answer questions from the court? Attorney Hermosura, please. Good afternoon.
Good afternoon,
Hermosura.
Justice.
My questions will focus on Section 11 of the Universal Healthcare Act, or the UHCA, which came into effect in 2019. May I ask the clerk of court to read into the records the relevant portion of Section 11 of the UHCA? Thank you.
With the permission of the court, Section 11, Program Reserve Funds, PhilHealth shall set aside a portion of its accumulated revenues not needed to meet the cost of the current year's expenditures as reserve funds, provided that the total amount of reserves shall not exceed a ceiling equivalent to the amount actuarially estimated for 2 years' projected program expenditures. Provided further that whenever actual reserves exceed the required ceiling at the end of the fiscal year, the excess of the PhilHealth Reserve Fund shall be used to increase the program's benefits and to decrease the amount of members' contributions. Any unused portion of the reserve fund that is not needed to meet the current expenditure obligations or support the above-mentioned programs shall be placed in investments to earn an average annual income at prevailing rates of interest and shall be referred to as the investment reserve fund. No portion of the reserve fund or income thereof shall accrue to the general fund of the national government or to any of its agencies or instrumentalities, including government-owned or controlled corporations.
Thank you, Attorney Cuevas. Now, may I call attention to slide 2? Can you please flash slide 2? Yes. Is on the screen, please. This is an illustration of how the accumulated revenues of PhilHealth are utilized every fiscal year. Current year's expenditures and the reserve fund are taken from the accumulated revenues. So please flash that one. Accumulated revenues are the source of the current year's expenditures and the reserve fund. Now, from the accumulated revenues, less the current year's expenditures can be taken the reserve fund. Okay, so can I have an illustration? For example, the accumulated revenues amount to 100 billion. All right. The expenditures amount to 70 billion. So that is equal to 30 billion, correct? Yes?
Yes,
Yes,
Your Honor.
sir. So it is from the 30 billion that you can source out the reserve fund, correct?
That's correct,
Very
Your
good.
Honor. A
All right.
portion or the whole of it.
Yes. So a portion or whole of it. So
Yes,
it
Your
can
Honor.
be 30 billion or 20 billion.
That's
All right.
That's correct, Your Honor.
So when do you apportion the whole of it as reserve fund? And when do you apportion only a portion of 30 billion
Well, I
as
think
reserve fund?
that is addressed to the business judgment of the PhilHealth Board, Your Honor.
Yes. So what guides the exercise of business judgment? What factors do they consider in determining whether they will input only a portion or the entire 30 billion? Would you know?
If you look at section 11, Your Honor, one factor that is mentioned could be the future requirements of PhilHealth, of the National Health Insurance.
Yes, you're talking about the 2-year actuarial estimate, correct?
Yeah, that's actually the ceiling.
The
For the-
ceiling is the 2 years or the amount corresponding to 2 years?
The amount that is equal to the projected expenditures for.
All right. So
That's the ceiling, Your Honor.
yes. So if the actuarial estimate for 2 years is 30 billion,
Yes.
all right, is it reasonable to earmark the entire 30 billion for reserve funds?
Yeah, I would say it could be, Your Honor, but there may
Yes.
be other factors.
Yes, I would like to know the other factors. Who can answer that?
I can make a guess, Your Honor.
I don't like to guess. Any expert who can determine the factors to consider. The executive of PhilHealth. Yes, President Ledesma. Can you please respond? And perhaps I will invite President Ledesma to stay in front and occupy the second rostrum. President Ledesma can take the other rostrum and Attorney Hermosura will stay and use the other one. Yes.
Good afternoon, Your Honor.
Good afternoon, Mr. President. All right, Mr. President, you heard my question. So, when do you portion, just a portion or part of 30 billion as reserve fund, and when do you sign the entire 30 billion? What factors do you consider?
Your Honors, we have an actuarial committee in PhilHealth that does a thorough study and thorough analysis with regards to the funding of PhilHealth. The actuarial committee regularly gives their recommendations to the Execom. We evaluate it in the Execom, and then we present it to the board, Your Honors.
Yes, I know, but I do want to know the factors that make you determine whether you're going to assign the entire money or just a portion of it. I know there is an actuarial estimate because you are into insurance, right? All right. So my question is very simple. If, by the way, which comes first? The determination of the amount of the reserve fund or the actuarial estimate?
The determination, Your Honor.
Determination of what?
So Your Honor, with your permission, so you were saying what are the specific factors?
Wait,
So
wait. I have shifted my question first. Okay. Which comes first? The determination of how much the reserve fund should be or the actuarial estimate?
Sorry, Your Honor, the actuarial estimates first, Your Honor.
Of course, you wouldn't know how much the reserve fund is if you do not have the actuarial estimate. So my question is this. If the actuarial estimate is 30 billion And based on the illustration, on the example, you also have 30 billion balance. Okay. Is it reasonable to assign the entire 30 billion to cover the 30 billion actuarial estimate?
Your Honor, with your permission, if I can answer your question by naming the different factors that are used to determine that.
Yes.
So if we'll break it down, Your Honors, we have, of course, the targeted benefit payments, and then we have our digitalization programs, and of course the plans for the corporation, and then we base it on that, Your Honors.
Oh, so you're saying that the estimate, the actuarial estimate, is not the sole basis for determining the amount of the reserve fund?
Yes, Your Honor.
Yes. Because the PhilHealth might have other expenditures, other items that you would like to spend out of the 30 billion, although your accumulated revenue has already earmarked 100 billion for the current year's expenditures.
Yes, Your Honor.
So 100 billion, which you earmark for your current year's expenditures, is not a fixed amount, because you can still charge 30 billion for the same purpose.
Yes. Yes, Your Honor. Just in case the estimates, the actuarial studies fall short, or our studies for the benefit payments fall short,
Yes, benefit payments should be included in the reserve fund. Don't you think so?
But Your Honor, for every year, we have a specific target or specific portion that is set aside for benefit payments.
Yes, I know that.
And if it falls short, if the target falls short, that's when we call on the fund.
All right. So if the actuarial estimate is 30 billion, but you do not want to assign the entire 30 billion to cover the estimate, there will really be a deficit. Don't you think so? And even if you assign the entire 30 billion to cover the actuarial estimate, it is still possible that you will have a deficit at the end of the fiscal year.
Yes, Your Honor.
Yes. So I would like to go back to my question earlier. When do you decide to just assign a portion or the full 30 billion to cover the reserve funds? Yes, Attorney Hermosura.
I can answer based on the Universal Healthcare Act, Your Honor.
Yes, Your Honor.
Because I have read the law, and the law does not prescribe the factors that the PhilHealth Board should consider. So that's why, in my view, it is addressed to the business judgment. And I have been in the boards of many companies, and I have seen the various ways business judgment can be exercised. Some people can be conservative, some people can be aggressive. I would say that I will not, let's say if I were in the PhilHealth Board, I will not set a high reserve fund if I am confident that I can get political support for a bigger subsidy for PhilHealth. Because there is no limit to the subsidy that government can provide to PhilHealth, Your Honor. And if I may also mention, the liabilities of PhilHealth are guaranteed by the Republic of the Philippines.
All right. So you mean to say that the subsidy of the government can come anytime, depending on the needs of PhilHealth? Yes?
It is settled, Your Honor, that a social health insurance is a matter of political negotiation.
Well, I do not know about that. I just want to simplify things.
Yes.
All right. Because if I were the PhilHealth and there is an estimate of 30 billion and I have on hand 30 billion, I will assign the entire 30 billion. Because anyway, PhilHealth has already assigned 70 billion for its current year's expenditures. All right.
Yeah, Your Honor. If I may mention that there is actually a downside. If the PhilHealth Board sets a high reserve fund. Because according to Section 11, for the members to have the benefit of reduced premium and to have enhanced benefits, then there should be a surplus. And surplus is created when the current year expenditures are lower than the reserve.
All right.
And so,
I'll go to that.
yes, so,
Yes.
yeah. Yes.
You're done?
Yes, Your Honor.
Yes, thank you. So if you say this is just hypothetical because we just want to understand, okay, in the simplest possible way. All right. So if you say your reserve fund is only 15 billion, all right, you get it, you deduct it from 30 billion, and your reserve for fund is only 15 billion. That is what PhilHealth earmarks. Then you have a fund balance, correct? Mr. President,
Yes.
will that create a fund balance? If you only earmark 30 billion, all right, so 15 billion rather, so 30 billion less 15 billion is, I know my math, 15 billion, correct?
Yes, Your Honor.
Very good. Okay, so how do you call the 15 billion? That, do you call it fund balance? Yes, Attorney Hermosura.
Well, actually, the fund balance is a concept under the General Appropriations Act, Your Honor, not under the.
Yes, but have you not applied it when you complied to transfer the funds to the National Treasury?
We made sure that the fund balance doesn't cover the reserve fund.
Correct. So the fund balance may be a concept by the Department of Finance or even by the special fund, the provision of the GAA. But the fact is that guided you, right, in determining whether you have fund to transfer to the National Treasury, correct?
That's correct.
Yes. So let's call it a fund balance. So from our example, you have a fund balance of 15 billion. Okay. Mr. President, what can you do with the 15 billion balance?
It will be
What can you lawfully charge to the 15 billion fund balance? Do you have a staff to assist you?
Actually, we have the treasurer also of PhilHealth, Your Honor.
Yes, the treasurer of PhilHealth can please
while waiting, Your Honor.
come to the rostrum as well.
Yeah, while waiting for the treasurer, Your Honor. Maybe SVP Renette can join.
Yes.
What we could do to answer your question, Your Honor, no? Well, if we need additional funding for operations, we will use that. If not, it will just be classified as income or it will fall under the net income. So it will depend on the situation, Your Honor.
All
So
right.
either to be used for operations if it needs to be. If not, we will just classify it as income, Your Honor.
So it's freewheeling. Is it freewheeling? It depends what needs to be funded.
Your Honor, on the whatever will be warranted. So if, like I said, if for example, the projections for the operations fall short, then we will be able to use those funds. No?
Right.
Now, if the projections are okay, then we will just set it aside as income, Your Honor.
All right. What if it is the reserve fund that falls short? Say in the middle of the year, no more reserve funds. Are you going to also assign from the 15 billion free fund or the, how do you call that?
Your Honor, with your permission, Your Honors.
The fund balance. Can you also charge the deficit in the reserve funds?
With your permission, Your Honors, if I can ask our SVP to assist me in because he's the one who handles the funding of
Yes,
PhilHealth.
please.
Thank
Yes.
you, Your Honor.
Also,
Your Honor, it will be the treasurer of
public, the Republic who will address the questions.
Yes,
Thank you, Your
please.
Honor.
For the record, please state your name.
State your
Your Honors, my name is Eduardo Marino. I serve as the Deputy Treasurer for the Bureau of the Treasury, and I serve also as the alternate of the Secretary of Finance to the Board of PhilHealth, and in that capacity, I chair the Audit Committee as well as the Board Risk Committee. So with your kind indulgence, Your Honors.
Yes, Mr. Treasurer.
Yes.
Mr. Treasurer is also a lawyer.
No, sir. No, Your
Ma'am.
Honors. Deputy Treasurer po, not the Treasurer.
Deputy.
Yes.
I'm already promoting you. You're not accepting because it's a void appointment.
Yes,
All
Your
right.
Honor.
So my question was, if the reserve fund at in the middle of the year is already deficit, okay, can the PhilHealth transfer a portion of the balance to beef up the reserve fund, the deficit of the reserve fund?
Your Honor, I believe the short answer would be yes, but if with your kind indulgence, may I go back to this example and to clarify a few terms?
Of course.
Okay.
Please do that.
So, Your Honors, I think we should start with the term revenue. The revenue is a flow that is only good for a single year's worth of operations. The term, I believe, accumulated revenues is a stock balance. So that's the, accumulated revenue. So that's revenues including of the prior years. So any single year, PhilHealth receives revenues primarily from premium contributions and of course the interest income. So that's a flow.
Wait, I would like to clarify that, no? You mean to say accumulated means the accumulation of revenues from past years?
Yes,
Yes.
Honors.
All right. So as of 2024, how much was the accumulated revenues of PhilHealth?
Right.
How much?
In end 2023, beginning 2024, that accumulated revenue for the financial statements stood at 464.29 billion pesos.
Billion. And this money, they're not invested.
They are invested, Your Honors.
Really?
Yes.
Are you allowed to invest?
Yes.
Yes.
Under the law.
Are you not allowed to invest only from the excess of the reserve funds?
Okay. The cash resources backing that the reserve funds have to be placed somewhere, whether that's a bank, a time deposit, or government securities, Your Honor.
Yes, but there is a limitation. Are you aware of Section 11?
Yes, Your
There
Honor.
is limitation on the investment, and the law imposes conditions before the PhilHealth can invest.
Your Honor.
Investment is in the least priority.
Yes, that's correct, Your Honors. If we can flash.
Are you aware of
Yes.
Section
Your
11?
Honors. Yes, Your Honors.
Yes.
If, with your kind indulgence, can we also flash that provision again?
Yes, please.
So to clarify further.
We will be guided.
So at least the way I would read this, Your Honors, of course I'm not a lawyer, is that the eligible balance that can be invested is the portion of the accumulated revenues that is not needed to meet the current year's expenditures. I believe that's the limit that you are referring to, Your Honors?
No, that I'm not referring to that.
Yes, any portion of the reserve fund not needed to meet the current year's expenditures.
Oh. Attorney Marife. All right. There's the portion of the reserve fund or income thereof shall accrue to the general fund of the national government or to any of its. I cannot read it. All right. Can I? Thank you. All right. Right. Any unused portion of the reserve fund that is not needed to meet the current expenditure obligations or support the above mentioned programs, meaning the program expenditures of PhilHealth
for the year.
For the reserve funds. I will read to you again. PhilHealth shall set aside a portion of its accumulated revenues not needed to meet the cost of the current year's expenditures as reserve funds, provided that the total amount of reserves shall not exceed a ceiling equivalent to the amount actuarially estimated for 2 years projected program expenditures. Provided further that whenever actual reserves exceed the required ceiling at the end of the fiscal year, the excess of the PhilHealth Reserve Fund shall be used to increase the program's benefits and to decrease the amount of members' contributions. Any unused portion of the reserve fund that is not needed to meet the current expenditure obligations or support the above-mentioned programs shall be placed in investment, earn an average annual income, etc., etc. So, investment is the last in the order of priority.
Yes.
Yes.
Yes. But Your Honor,
So
I would like to highlight that every year PhilHealth actually generates more revenues than expenditures, such that whatever's needed for the year is actually being more than enough more than met by the inflows, the additional revenues for the year.
Yes.
That in that addition, that net income, Your Honors, is being plowed back into the reserve fund.
Yes, but later I will show you the report of COA, which shows that PhilHealth is bankrupt, actually. I don't know if you're aware of that. You ought to be aware.
If you are, Your Honor.
And COA has repeatedly highlighted that in its letters to PhilHealth. And then COA said that for many years, at least 3 years, 21, 22, 23, the reserve fund of PhilHealth is much, much less than its actuarial fund, actuarial estimate. And I will show you later. All right. So coming back to you took the rostrum.
Yes.
Because you're supposed to assist, all right, in telling us what factors should be considered in determining whether the entire amount of the balance, no, should be assigned as reserve fund or just a portion of it. And yes, the president said there are factors to consider. What are these factors?
Primarily, Your Honors, what is the reasonable to projected 2-year expenditures? That is the sole factor at the very least when that was discussed by the board and contemplated by the DOF.
Reasonable. Do you mean by reasonable? You know, that is such a subjective term. Standard. Yes. What is reasonable?
In this case, Your Honor, it would be the demonstrated capacity of PhilHealth to spend its resources every 2 years for the last 5 years or so.
Well, that is quite a big phrase. The capacity of PhilHealth to
spend their resources.
The capacity to spend, not the capacity to spend. You mean the funding?
No, their expenditures.
Their expenditures. Yes. All right. So you mean to say that if PhilHealth has big expenditures, large expenditures, okay, the possibility is that the balance will only answer portion. It will only assign portion.
Yes.
Yes. Such that if PhilHealth expenditures are at a low level, the reserve fund may be charged fully to the balance. The balance may be assigned entirely to the reserve fund. Correct? Yes.
Yes. No, Your Honors, the reason why I hesitated is because we just need to be particular on the terminology. We use accumulated reserves because we introduced that term. If PhilHealth has demonstrated, shown that with its expanded benefit that it can actually use the full 464 billion within the next 2 years or so, then there is going to be no fund balance to speak of because the 2 years projection would be 464. But in the evaluation of the DOF, their demonstrated capacity for the last 5 years, 2018 until 2023, that level of expenditure they were only be able to accomplish was about 280 billion.
All right. So you're saying that when your actuarial group fixes the estimate at, say, 30 billion, all right, you are not certain whether the PhilHealth is fully capacitated to pay off if that actuarial estimate becomes real, okay? The real amount by the end of the fiscal year, you are not sure whether the PhilHealth by the end of the year will have the capacity to pay off the obligations incurred under the reserve fund.
Your Honors, in my experience, the calculations provided by the acting actuary is actually significantly more than what PhilHealth has spent.
All right. Can you give a concrete example? You mean to say actuarial estimate is exaggerated?
It has not materialized, Your Honors, in actual expenditures. To give a concrete example, if I remember correctly, and of course that would be subject to confirmation, in 2022, the projection of the actuary of PhilHealth is about 470 billion in the next 2 years.
Yes.
At no point in the last 5 years, even during the COVID-19 pandemic, did PhilHealth even reach a levels comparable to 470 billion.
What do you mean comparable?
They had the...
Give me a comparable amount.
Your Honors, for 2020, again, the average that they have spent, 2-year average that they have spent is about 280 billion.
All
during
right.
this period.
So around 50%.
Yes.
So actuarial estimate is only 50% accurate. Yes. That's why I think, was it Professor who said that PhilHealth should invest hard on having a strong actuarial department?
Yes.
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 It is an assessment that I would personally agree with, Your Honors.
Because it always missed.
Yes,
no?
Your Honors.
It always missed. It exaggerated, but PhilHealth does not believe it. You never believe its estimate, right?
The board, at least I do not.
You do not. Okay. So that actuarial team still exists?
I believe so, yes.
All right. So you're saying that this is what I gathered from your responses, that notwithstanding that expenditures have been pegged, for example, at 70 billion, you can still incur additional expenditures, right? Which you can charge to the balance.
Yes.
That's why, as a rule, please correct me if I'm wrong, as a rule, you only assign portion of the balance to the reserve fund.
Yes, Your Honor.
And did it ever occur that you assign the whole balance as reserve fund?
In the actual data of PhilHealth, the 2-year expenditure of 280 is far below the accumulated revenues of 464 when the year started, when 2024 started, Your Honors.
So you never assigned the entire balance to cover the reserve funds?
No, Your Honors.
Yes. Will you say, though, that part of the balance, less reserve funds, you can also use to cover the deficit of the reserve funds?
Yes, Your Honors.
Mid-year?
Yes, of course, Your Honor.
Yes. Have you done that?
No, because as highlighted, Your Honor, PhilHealth has not actually breached, or at least its expenditure level has stayed relatively stable.
Yes. So are you saying also that you are prompt in your payments to your creditors,
No,
to the beneficiaries?
Your Honors, given the massive amounts of complaint, I cannot make that claim.
So you breach it because you're saying now that you're not paying it in full, correct? You have unpaid liabilities.
That is correct, Your Honors. But if I may highlight, Your Honors, the PhilHealth adopts accrual accounting. That means the expenditures of PhilHealth reflected in the income statement is actually inclusive of those debts, hospital claims hospital claims that were filed, and even those that were not filed is being included in the expenditure.
Yes, but you have not paid your liabilities in full.
Yes, Your Honor.
Yes, and you have unacknowledged, unrecognized liabilities.
They are recognized, Your Honors, in the statements of financial positions. Specifically,
yes, you have recognized, you have unrecognized. They're like children.
It is recognized, Your Honors.
Recognized, unrecognized.
It is recognized, Your Honors.
All?
The financial liabilities.
Next time I will ask the Solgen, because the Solgen said there are unrecognized liabilities. No? All right. We'll get to that. Okay, when the Solgen turn comes. But you never not recognize any liabilities. All your liabilities you recognize. Correct?
Your Honors, I cannot make an unequivocal statement because PhilHealth actually rejects claims. And of course, your hospital service provider and healthcare institutions can refile, appeal for the approval of their claims. So,
All right. So are you saying all the recognized or approved claims are promptly paid by PhilHealth?
the representation of the president is yes.
Yes. How prompt is prompt? So far as PhilHealth is concerned.
The data of PhilHealth management is 23 days for good claims.
23
days for good claims, Your Honor.
for good claims. All right. So if a claim is lodged to PhilHealth, how long does it take for PhilHealth to process the claim?
There is no distinction between good claims are not distinguished by their large
My question is, how long does PhilHealth process
the
the
average,
claims?
Your Honors, the average is 23 days regardless of size. The average
The average. 23 days?
for good claims, Your Honors.
So how would you know if it is good claims if you don't process first? Oh, if it is a bad claim, how long should you process a bad claim? You won't be able to ascertain at once, right?
Your Honors, PhilHealth also tracks what they call accrued claims, the ones that fall short of their usual requirements.
Claims should be processed.
Yes.
Correct?
Yes.
And it takes time to process.
Yes.
All right. So for good claims, you said 23, but you cannot instantly identify what will I process for only 23 days? What will I process for beyond 23 days? What will I not process at all? All
Your
right.
Honors.
Now, reserve fund. Okay. When do you incur an excess? Yes. When does an excess reserve fund happen?
It would be when the two-year expenditure ceiling is reached or breached or exceeded. Yeah.
Reserve excess. I'm talking about excess reserve fund. Attorney Hermosura, can you respond to that?
Yes, Your Honor. According to Section 11, there's an excess when actual reserves exceed the required ceiling. And that required ceiling is the projected
Yes.
2 years.
So, for example, in 2 years, you have the estimate. Are we still talking of the actuarial estimate?
Yes, but the actuarial estimate has to be approved by the PhilHealth Board.
Correct. Assuming it has been approved.
Yes.
All right. So, if the actuarial estimate, the ceiling is 400 billion. All right. So, when does an excess reserve fund happen?
When the excess, let's say the reserve fund at that point is 500 billion, Your Honor, and the ceiling is 400, then there is an excess of 100.
Yes, an excess of 100.
And
yes.
that becomes like a retained earnings of the company because it can then return it to the members by way of reduced contribution or enhanced benefits.
All right. Let's go back to Section 11. That whenever actual reserves exceed the required ceiling at the end of the fiscal year, the excess of the PhilHealth Reserve Fund shall be used to increase the program's benefits and to decrease the amount of members' contributions. Have you done this? Have you had in the first place excess reserve?
Yes, right now. That is the situation right now.
So what is your excess reserve?
As of September 2024, that is about 144 billion as
Excess.
FS.
Excess.
Yes.
All right. When you say excess reserve fund, is the excess of the reserve fund that you have earmarked from the fund balance?
I'm sorry, Your Honors. Wasn't clear. If I may ask the question again.
Yes. The excess reserve fund. The reserve fund is sourced from the fund balance, correct? After expenditures have been deducted from the accumulated revenues. Is that correct?
Maybe we can ask the COO of PhilHealth, Your Honor, because he's more involved
Yes.
how PhilHealth manages these things, Your Honor. But from what I can read though in the law, Your Honor, in order for an excess to happen, a ceiling must first be set. And
Correct.
set
Correct.
because
In our example, the ceiling is 400, and then you have a reserve fund of 500. So there is an excess of 100.
yeah,
Correct?
I have only heard a number for a reserve fund from PhilHealth, but I have not heard about the ceiling that the board has set.
Yes, but Mr. Deputy Treasurer indicated a what is that? A ceiling of 400.
Your Honor, sorry, as the OGCC has mentioned, the only terms in the financial statements are the reserve fund, which is the 2-year ceiling, and the surplus. So
That is, where did you get that?
which one, Your Honor?
The excess, did you say surplus?
The surplus is in the financial statements of PhilHealth.
That's a new term. That's not found in the law. Is it found in section 11?
It is not.
It is not.
No.
So it's your own term.
It is the term
Yes.
described by COA, Your Honor,
Surplus. COA call it surplus.
in the FS, yes.
All right. So instead of calling excess reserve funds, COA is calling it surplus?
Your Honor, one of the difficulties of, if I may expound, Your Honors, one of the difficulties faced by PhilHealth as well, management, is exactly that term, actual excess reserves, because by law, the provision, the reserve simply cannot, has a hard ceiling, 2 years. So it was a difficult, it is actually difficult to operationalize what would be an actual excess reserves. One of the discussions, one of the technical discussions, Your Honors, go something like this, if you may, with your kind indulgence. Hypothetical. Right now, the prescribed 2-year ceiling of PhilHealth is 280. Yes?
I don't know.
Yes, it is. As reflected in the FS, Your Honors. Apologies. After 2 years, that means by 2026, PhilHealth will have a record of its operations. It will have a record of its expenditures. If the expenditures in the next 2 years is only 240 billion, that difference, that between 280 and the 240 can be treated as the excess reserves, actual excess reserves. That is one of the more reasonable ways to operationalize this provision, Your Honors. But admittedly, it is very difficult.
No, to operationalize it is to stick with the provision, not to deviate from the provision. The provision is quite clear. Huh? It's very clear. All right. It leaves no room for interpretation. It speaks of actual reserves. It speaks of reserve fund. It speaks of excess. That any excess reserve fund should be used to increase the program's benefits and to decrease the amount of members' contributions. And if there is still an excess of the excess, the same should be, may be invested. All right? So investment is the list of the priorities. So what I am made to understand now is that PhilHealth is not exactly complying with Section 11. That your investment comes from all sources. Not, and then you prioritize investment over the programs that will increase its benefits to the beneficiaries and decrease the amount of members' contributions. That is what I gathered from your statement. All right. Yes, Chief Justice, may I continue next time? Thank you.
Considering it's
You're excused, Chief. In the meantime, the two of you are excused. Thank you.
Thank you.
considering it's already 6 o'clock by the court's time, we're close to it. The session today is adjourned to continue on February 25, 2025 at 2 p.m. also. Attorney Maripe? Are there other matters?
There are no other matters, Your Honor.
Okay, there being no other matters, the court hereby adjourns.